Thank you very much.
The hearings in the matter of case number CFI 15/2019 before Justice Sir Jeremy Cooke. The claimant is represented by Mahmoud Hussein Law Firm and the lead counsel is Michael Patchett Joyce. The defendant is represented by HFW and the lead counsel is Stephen Doherty. Thank you very much.
Yes.
Your Honor, I'm obliged. Your Honor, it's for me to begin. My name is Michael Patchett Joyce. I'm lead counsel, as you've just heard, on behalf of the claimant, Mr. ABDELSALAM. Learned friend, Mr. Stephen Doherty, is counsel for the defendant, EXPRESSO Telecom Group Limited. We have, and I'll come to it in very short order, a trial timetable which includes housekeeping and openings on behalf of both parties. But first of all, having introduced counsel, I should just check that the court has and has ready access to the bundle for hearing, which numbers, I think, as it currently stands, 1,556 pages in such form as is convenient to the court given that there's a new case management system.
I have the new case management system before me. How convenient that is another question, as you know from past experience, Mr. Patchett Joyce. But I did print off some of the material in any event. But if you're going to refer to something that's on the case management system, if you do it by reference to that, then I shall be using that.
I think we may be at risk of being bedeviled by the same problem that bedeviled the previous hearing. I'm working on page numbers to the bundle rather than the sub sections in the case management file. I do have those instructing me on the line, and they can.
What I was just going to say, Mr. Patchett Joyce, is let me just check that the page number. If you gave me, for example, what let's say 542. Let's see what happens if I type 542 in.
Should say something beginning with Schedule B.
Yes, that's exactly right. So that does appear to work. Yeah.
Fantastic. That's going to smooth things, I hope, considerably. Following on from the pagination exercise we've just undertaken, Your Honour will doubtless have located the skeletons on behalf of both parties. They may indeed have been supplied separately. In the bundle, the claimant's skeleton is at page 1088 and running through to page 1109.
Well, I printed those off, so that's easy.
I'm obliged. And I was going to give you the same page numbers or the corresponding page references for Learned Friend's skeleton, but that perhaps is superfluous. Your Honour will find at the back of the bundle, before we get to legal authorities, a list of issues which is at pages 1553 to 1555.
Thank you. I haven't identified that.
Sorry, 1553, 1555 is after the authorities, because the list of issues was actually omitted by oversight from the original bundle. So it's right at the very end.
Yeah, I have it.
And I think that doubtless my learned friend has done the same exercise. I certainly had regard to the list of issues when drawing up the skeleton argument. And although I've not followed slavishly the list of issues, it's my understanding that everything has been covered. And the reason why I didn't slavishly follow the list of issues is because some issues are raised in more or less identical, certainly very broadly similar form, as a legal issue or as a factual issue, and therefore it's pointless to break it down in that way. But of course, at the conclusion of the hearing, we can revisit the list of issues and make sure that all matters have been covered. There is also, Your Honour, a chronology at page 1082 to 1086, it's certainly helpful. There are some issues where there are differences. Those differences are highlighted in respectively blue and red. I think that none of the issues will come as any surprise. It's simply the position taken by the respective parties. But having dealt with the skeletons and the list of issues and the chronology, if your honour turns back to page 1080 and 1081, there is an agreed reading list, perhaps not in the most user-friendly location, but it was because there'd already been an agreed reading list that I didn't, I'm afraid, include one at the start of my skeleton argument. I ordinarily would. It's customary to do so. The reason why I didn't was because of the agreed reading list that's there. And then at the page 1087 is the trial timetable. Which starts with the housekeeping, which we're covering now. I'll then move to my opening statement. The learned friend will have the same length of time for his opening statement, 20 minutes, and then we will start the evidence of Mr. MUSAAB, the claimant, with a break for an inverted commas lunch adjournment, because I think it's a rather late adjournment in Dubai. It's a rather early adjournment here, but it I think meets the need. Then there will be the conclusion of Mr. MUSAAB's evidence, a break, and then the evidence of the witness on behalf of the defendant. So I hope that that is a convenient trial timetable for the court.
Yes, thank you. Let me tell you what I haven't done. On your agreed reading list, I have not read all the pleadings. I read the amended particulars of claim, and I haven't read the other pleadings, though I have obviously from the skeletons and so on got a pretty clear sense of what's going on. But just so you know that, I've read all the witness evidence. One thing I'd like particular help on, which you will come to in due course, not having had time to look at the law in any detail, is the question of how acknowledgement of debt works.
Indeed.
So if, to make the obvious point, if I acknowledge in a letter that a given sum is owing for a particular head of claim, does that have the effect of extending time simply in respect of that which I have specifically acknowledged, namely the specific sum for the specific head of claim?
Yes.
From my limited reading, I understand that much depends on the terms in which the acknowledgement is expressed, so that it might have a wider impact, it might not. But I shall need some help in relation to that.
Well, Your Honour, Your Honour will have seen that the what I submitted, the relevant cases, are
yes, I haven't
set out. No, indeed. What I was going to do was perhaps take an extra 5 minutes in relation to my opening. I'll still try to keep to the timetable, but I'll take Your Honour to the relevant paragraphs in those cases.
Yes, all right. Well, that would be helpful. And the other sort of big area of difference relates, does it not, to the whole question of end of service gratuity and how that operates. And I may need a little bit of guidance in relation to that. Obviously, I've dealt with cases on this before under different pieces of legislation. But again, I will need some help from both parties on how it works in this case in relation to the various changes in legislation as it went forward. And the last thing I just wanted to say was this. I have some recollection of another case between these parties relating to, I think, a 2019 contract of employment. Am I right?
Well, it's certainly not something which immediately springs to my mind. There was an earlier case involving EXPRESSO Telecom and another claimant, Mr. Raham Talla. And that I do, in both my learned friend and I have some knowledge of that case because we were both involved at the Court of Appeal stage.
Well, CFI 0562021 is a case that springs to mind.
I wonder if Your Honour could give me that reference again.
CFI 0562021. It was quite by chance, in a sense, that I appreciated this, because I was looking for any papers that I had on the case and came across this case, the one I've just mentioned to you, which relates to the same parties, and which I see from my notes I've had various dealings with in 2022, including there was a payment into court, and there was an order for costs, and I lent on the parties as much as I could to settle the case, because it seemed to me there was very little money in it, however one looked at it. And there was a lot of vituperation and a lot of heat and not very much common sense being talked at the time. So I rather have assumed that it did settle following that. But the only point that occurs to me is that in this context, that litigation may have relevance because it may relate to contracts that went on after those that are the subject of these proceedings.
Your Honour, I think I may be able to shed some light on that, if I may just. I think if Your Honour looks at the full name of the claimant in CFI 056/2021,
Right.
the full name was Mr. Tariq Mohammed ABDELSALAM Abdul Rahman.
Oh, right. So it is entirely different
My
person.
client is Mr. MUSAAB Tag ELSIR ABDELSALAM. They
I'm
are
so sorry.
similar. No, Your Honour, it's very good that we should be able to clear this up right at the outset.
Yes.
And I was beginning to doubt my own indexing referencing, because I'd looked obviously in the judgments of the court, and certainly CFI 056/2021 didn't jog any bells, didn't ring any bells as that in that regard.
Different person. Thank you very much.
Different person, Your Honour.
Very good. Thank you. That's very helpful.
Well, I'm very much
I've probably
obliged
revealed more than I should have done about another case, but never mind.
I don't think you revealed anything at all untoward in either direction, Your Honour, and I should say I'm grateful to those instructing me for being able to clarify the point.
Yes, thank you.
Your Honour, obviously, by way of opening statement, I know where I need to focus some more attention than might otherwise be the case. Let me just make some very preliminary comments. They're not intended to be exhaustive, they're not comprehensive, but they are comments on the defendant's skeleton, first of all.
Yeah. Yes.
Essentially, if I can put it compendiously, the issues are. Sorry, I should allow Your Honour a moment.
It's all right. I'm still here. I'm just putting away the other bundle that I now see is completely irrelevant.
Well, Your Honour, I was going to just make some very short introductory comments. not exhaustive, not comprehensive, but on the defendant's skeleton. Essentially, as Your Honour has seen, and just from what Your Honour has been saying so far, issues are essentially joined, both in the pleadings and in skeleton form. So I'm not going to go into those details. I'll await my learned friend to open his case in the way that he sees fit. What I would say is as follows. The learned friend at the outset of his skeleton places considerable stress and emphasis on the consultancy agreement, which he says affects the position both as regards agreements 1 and also that it goes over and has a continuing effect in relation to agreements 2 and 3. We fundamentally disagree with that. Of course, it's common ground that the consultancy agreement was never an agreement at all. It was only ever in draft. And further details will be explored in the course of cross-examination. So I won't say anything more in that regard. The limitation point, which again forms a substantial part of my learned friend's case, that interfaces and interlocks and interacts with the acknowledgement of debts point, and I will come to that more fully in setting out my stall and taking the court to the relevant authorities. The third point that I would draw to the court's attention is that my learned friend has embarked in a very intricate exercise spanning many paragraphs, particularly paragraphs 59 to 78 of his skeleton argument, where he endeavours to say that there is no scope for penalty in this case. We say that that is an elaborate attempt to circumvent what is inevitable, and we would go so far as to say that it's obvious. And one goes back to the core language of the statute, which talks about years of service, and for all sorts of reasons which we've again elaborated in the skeleton argument, it cannot be that you can circumvent the effect of aggregated cumulative years of service simply by the simple expedient of having a series of fixed term contracts. And indeed, there's authority which supports our position in that regard, which we've set out in our skeleton. The learned friend hasn't commented on that. I'll obviously answer any point that he makes in answer in due course. He says that penalty had not been pleaded until either January 2022 or the amended particulars of claim served on the 17th of April this year. Your Honour, that is, I'm afraid, fundamentally wrong. And it's wrong for this reason. If the court could take the bundle electronically or in hard copy and look first of all at page 13, well, perhaps I should begin so that the court sees what document it is, at page 8, the original particulars of claim. And Your Honour, if the court goes to, first of all, page 13, there is a heading cause of action. And one reads through this. It may be set out in slightly dense format, but it is quite clearly a summary of the causes of action. And if Your Honour looks at the text, you can see that there are bold words of, first of all, Exhibit 2, and then 2 references to Exhibit 3. And if we look at Exhibit 3, what is said, and it is the case, we can look at the legal notice if need be, but a legal notice was served upon the defendant by the claimant on the 22nd of March 2018, annexed and marked as Exhibit 3, notifying the former to honour such payment withheld, along with penalty for non-payment of the claimant's dues as accrued since 2014. Now, the dues which have accrued since 2014 is plainly the penalty, because everything else accrued before that date. Then, when one goes on to the entitlement to compensation, to damages and compensation, which is pages 19 and 20. At paragraph 16, the foot of page 19, it's pleaded that the actual claim value sans the penalty for non-payment of the claimant's dues that accrued since 2014 is, and the reason for that obviously is because the previous heads of claim could be quantified, but the continuing nature of the penalty could not. Then we go on to paragraph 17, where it's stated on line 3, and in default of articles 18, 19, and other paragraphs, or other articles of the DIFC Employment Law number 4 of 2005, well, articles 18 and 19 form part of part 3, and that covers penalties. Then one goes into the prayer, A2, defendant has breached and contravened provisions of law under, including articles 18 and 19 of the DIFC Employment Law number 4, 2005. So that was clearly set out right at the outset. Now, what we were asked to do in the amended pleading, which Your Honour now has, is set out at page 439. Page 439. In particular, paragraph 2, the claimant shall file compliant particulars of claim. And the most important element is in accordance with paragraphs 88 and 89 of the Court of Appeal's judgment. Now, those paragraphs are to be found back on page 420. And in particular, it's paragraph 88. It's clear that initially the appellant was asserting a cause of action for breaches of or arising out of the 2005 employment law. It is the asserted facts that define his cause of action rather than the particular law which he invokes. He should therefore have leave to amend his particulars of claim in order to invoke such provisions of the 2005 employment law as support the relief which he claims by reference to the facts which he has alleged. Then if one goes to the most recent amended particulars of claim, and of course we can go through the intervening pleadings should the need arise, but the most recent amended particulars of claim start at page 334 in the bundle. And paragraph 13 is at page 344 in the bundle.
Yeah.
And it is unchanged throughout every incarnation. So the same plea along with penalty for non-payment of the claimant's dues as accrued since 2014, is clearly maintained like a seamless thread through all of the incarnations of the pleadings. And then at paragraph 17 now, the defendant therefore is in breach of his contractual obligations pertaining to, etc., and in default of part 3. Now, part 3 is the part which is protection of wages and includes articles 18 and 19. What we've then done, because the request of the Court of Appeal was to identify such provisions of the 2005 employment law as support the relief, is it to reinstate the express reference to Article 18, but it's always been there. And then one goes through to the same prayer for relief, where the prayer again speaks of the defendants having breached and contravened the provisions of the DIFC employment law, in particular Articles 18 and 19. So in our submission, it's completely wrong for my learned friend to assert that the claim for penalties first saw the light of day in either January 2022 or April 2023. It saw the light of day right at the outset of the pleading of this case. The next point I would raise is in relation to statutory notice. Again, the defendant cannot, nor can any employer, use a series of fixed-term contracts to avoid the notice provisions. And indeed, it would appear from the contemporaneous evidence that the defendant was fully well aware of that position. Further, as regards quantum, we have set out in claimant's skeleton quantum, either where it's been necessary to calculate it by reference to daily wages and basic wages and the like, by doing the sums. Otherwise, by taking the court to the contemporaneous documents in 2014 and onwards in relation to the acknowledgement of the debt. So, Your Honour, that's what I say by way of brief comment on my learned friend's skeleton. It's not exhaustive. I'll deal with that in due course. But may I now turn to the claimant's skeleton in the time that remains available to me, and briefly cover that, mindful of the fact I need to cover certain case law as well.
Are you going to say anything at all, though again I appreciate this is a matter of cross-examination rather than anything else, about the 1st of September 2009 contract between Sudatel and the claimant?
Well, I was rather going to leave that over until cross-examination.
All right.
It certainly forms part of the cross-examination, and it's difficult to foresee where things will land once the cross-examination has taken place. I
understand that, which is why I'm not pressing you on the point, because it may well be best left until after we've heard the evidence. But
yeah, that was the value judgment that I took. It hasn't been lost sight of. It'll be covered. But Your Honour, I'm very much obliged for the indication that that is obviously part of the factual matrix.
Yes.
If I may turn to the skeleton argument for the claimant, and of course in this regard, we essentially say on the Sudatel contract that this court is seized of the contracts or the agreements 1, 2 and 3, where contracts of employment from 2008, 2010, 2012. It's not seized of anything to do with a contract which was in a completely different jurisdiction, and where after the events that we're presently dealing with, issues have arisen in that jurisdiction in relation to that contract. It's really
well, I understand that, but obviously the interrelationship between the two may or may not be of significance.
I take that point, and that is a point which will be covered in cross-examination. The skeleton argument, very briefly, and I'll take this as quickly as possible because I know the courts had an opportunity to read it. Paragraph 1, the 3 agreements are set out with references. The terms of the agreements or contracts of employment are then summarised. Again, I haven't given precise page references for the particular clauses which are set out. They are thankfully relatively short contracts of employment, but it helps the court to navigate. So we say that the claimant was an employee within the meaning of Article 4 of the DIFC employment law, and then we revert on one specific point to the list of issues, because the list of issues raises at issue number 10 whether the claimant's employment was validly terminated for cause. I can see nothing in the pleaded case, or indeed in Malone and Friends' skeleton argument, which would give rise to that issue being raised. So it's a canard, it's a red herring, depending on whether you want to describe it in French or in English, and it can safely, in our submission, be left on one side because there's no basis for any contention of termination for cause in this case. Jurisdiction, this is very much the point that I summarised in relation to Sudatel. That covers paragraphs 6 to 8, and indeed point 9 and point 10. We then get to the heads of claim under Agreement 1. I hope they are sufficiently summarised. Under Agreement 2, similarly, under Agreement 3, likewise, plus the end of service gratuity, the failure to terminate Agreement 3 as provided under that contract of employment, and statutory penalties. On the relocation allowance, again, I'm happy to take the court to the page reference if needed. There is at page 794 express provision for that relocation allowance to be paid. I think it's common ground that the defendant hasn't paid that sum or anything towards it, and indeed the defendant has acknowledged that debt, as we'll come to. Other claims arising.
Well, it's exactly that area where the Sudatel contract might be of relevance. The interrelationship where there's, on the face of it, a duplication of provisions, one has to sort out. I merely note that I may have misunderstood the position. You can take it that I've read all the contracts.
I'm very much obliged, Robert.
So no need to go into that. And again, probably better left until after the evidence has been heard. But
may well be right. And just to pick up the point that Your Honour has raised, of course, my client's case is that the purpose of the Sudan arrangement, however it was put, was simply to provide per diem compensation for out of pockets, and I'll oblige. Let me now turn to acknowledgement of debts and the limitation period. I think it's common ground that Article 38, and Malone and Friend also relies, I think, on Article 123 of the contract law, that the period of limitation applicable is 6 years. So given that Agreement 1 commenced on the 1st of November 2008, no claim under Agreement 1 could be subject to a statutory time bar until at the earliest the 1st of November 2014, and obviously the time bar in relation to Agreement 2 and Agreement 3 correspondingly pushed further beyond the 1st of November 2014. Then I take the court back to the causes of action, a paragraph that we've already looked at, but in the course of that, there is reference to email correspondences, which were exhibited as Exhibit 2 to paragraph 13, contents of which it says are self-explanatory. And the explanation is that the parties were discussing the sums owed by the defendant to the claimant immediately after the expiry of the term of Agreement 3, so immediately after the 31st of July 2014. Then on the 25th of August, the defendant acknowledged that it owed sums to the claimant in respect of identified heads of claim. And I don't know whether Your Honour's had an opportunity to look.
Yes, I've looked at each of the acknowledgements of debt that you rely on in your skeleton.
I'm obliged.
And seen the figures and so on and so
Yes.
forth, which is why I raised the question that I did at the earlier stage.
Yeah, absolutely. The full references are set out in footnote 7 over the page.
Yes.
But before I get to that, I've covered gratuity and the statutory entitlement arithmetic calculation. Unpaid salaries, we acknowledge, or the defendant has acknowledged, that it should pay all rightfully claimed heads of claim. So what we say is look at the pages that we itemized at footnote 7. That clearly constitutes express acknowledgement in respect of relocation allowance, leave encashment, air tickets, and by necessary implication acknowledges the debts in respect of further salary claims. It's not suggested that my client was not right in saying that he wasn't paid. The defence is limitation. We say, well, if the defendant says that it acknowledges an obligation to pay all rightfully claimed heads of claim, that suffices. Now, I should take the court to the cases that I have set out in paragraph 25, or referred to in paragraph 25, and Ross and McGrath is to be found at page 1411 of the bundle.
Yes.
And if Your Honour turns on to page 1415, at the foot of that page, there is a section beginning the relevant principles. And helpfully, the principles which the authorities support are set out in a series of propositions. 1, the debtor must acknowledge his indebtedness and legal liability to pay the claim in question. 2, an acknowledge, I'll not read the supporting references for reasons of economy of time. An acknowledgement need not identify the amount of the debt so long as the amount is capable of ascertainment by calculation or by extrinsic evidence without further agreement of the parties. Extrinsic evidence is admissible to identify the acknowledgement with the debt. The debtor must acknowledge his indebtedness and legal liability to pay the claim in question. I accept that the authorities do indeed support these propositions, so that's confirmation that that's an accurate summation.
Is this the judgment of the court or of
one
particular judge?
It's the judgment of Lord Justice Clark, but I think the other two simply agree. Page 1419, Mr. Justice Jackson and Lord Justice Tuckey agree. So it is one judgment, but essentially the judgment of the court. One oddity which I identified is that in this list, it is numbered 1, 2, 3, and 6. That is indeed how it appears in the copy judgment. I can only assume that it's fat digit syndrome and 6 should read 4.
Sorry, I'm not following the point, but
Under the relevant legal principles that I've just read, they are numbered.
oh, I see. Yes, okay.
Right.
Yeah.
Paragraph 17. I accept that the authorities do indeed support these propositions. Subject to this, I refer to two further cases.
It was probably Roman numerals originally.
It could have been,
and so 4 became 6 by a mistype.
By a mistype, yes, it could indeed. I refer to Lord Justice Clark refers to two further cases which illustrate the propositions. Yeah. First is Camus, where Mr. Justice Parker said at page 209, it is clear that an acknowledgement in the statute does not have to say in terms, I acknowledge that a certain sum is due. Does have to get as far as being an admission that something is due and something must be ascertainable by extrinsic evidence. And the second case is Dungate and Dungate, already referred to, and there's a citation. There is clear authority that an acknowledgement under this act need not identify the amount of the debt and may acknowledge a general indebtedness provided the amount can be ascertained by extrinsic evidence. Then paragraph 18, which is quite a long paragraph, puts the matter in context. And over the page, finally, under this head, there is a further principle of some importance. It is that the letter must be construed as a whole. Obviously, that's in relation to a letter. We have the defendant's own calculations here. As Mr. Justice Carr put it in Surrendra, the statement relied upon as an acknowledgement must be taken as a whole, and a party is not entitled to pick out parts and ignore others. Well, that's what we're doing. That is not what we are doing. But because that's the entirety of the legal principles in that section, for completeness, I've taken the court to everything there. Then,
so if I was to try and simplify that slightly, Mr. Patrick Joyce, in the present case, as I read it, it's saying that the amount in question can be ascertained by reference to extrinsic evidence without the agreement of the parties. But what it means is that it is the amount that is admitted either expressly or by application that is the amount for which limitation period is extended.
Yes.
So it wouldn't matter if you claimed £50,000 and there was an admission of liability of £5,000 if it was clear that actually admission of 5 extended to the 50. But if it is simply an admission of 5 and there's nothing else, then time's extended for the 5 and no more.
That's my understanding of the law, Your Honour.
Yeah, yes. That's what I thought. So in the present case, where I've seen specific figures, unless there's other correspondence at the time which show something different, those are the figures that I'm entitled to say time would be extended for.
Your Honour, yes, and that's why I have referred back to those documents in those instances.
Understood.
And I think the only other matter that I need take the court to is Ramis Edwards, which begins at page 1487. And the paragraph that I rely upon is paragraph 17. Which is page 1492.
Did you think the last system was better than this?
You might think so. I couldn't possibly say.
Well, no. I mean, the court will want to know how users find it. So,
well, rather than adopt House of Cards circumlocution, yes, I preferred the previous system.
Well, can I just say this, because the court wants to know how users find it. If that's a general view amongst users, people ought to write in and say so. Say that, you know, I mean, the court's doing its best to make life easy.
Yes, yes. I'm just slightly concerned about reading something into a YouTube transcript, which then has.
I understand that entirely, but and you fairly said you found it so at present. But all I'm saying is the court wants feedback on this.
Yes.
In order to get it as good as it possibly can.
Yes, and it may be that familiarity with a new system
Yeah,
means that one can
exactly so.
navigate it. And I think indeed there's a user manual which I now have, which I think sheds some light on it as well. So
and they did offer the judges some classes, which I haven't, I'm afraid, taken up. So deficiency is undoubtedly my fault in part.
well, I must say I've not fully got to grips with the written manual myself. But perhaps I can take the court to paragraph 17 of Ramis Edwards, which doesn't say very much, but it completes the picture. Page 1492, whether a statement amounts to an acknowledgement is a question of construction, decided cases therefore of limited value, etc. But it cites Chitty on contract in the 33rd edition, well established by case law that the debtor's statement must be considered as a whole. Is back to the surrender point, which has already been noted. Extrinsic evidence is admissible not only to identify the debt and to ascertain its amount, but also to link one document with another, so that when read together, there is an acknowledgement, again, a Chitty reference, and reference to Ross and McGrath, which I haven't actually, I stopped short of paragraph 21, but it's what would reasonably be understood. And we say what would reasonably be understood is crystal clear in the circumstances of the present case. So going back to the skeleton, that is the law that we rely upon, and we say there have been express and necessary, and there has been acknowledgement both expressly and or by necessary implication. We then move from agreements 1 and 2 to agreement 3. You've read the agreement 3. I've set out clause 6 extensively, and this is with regard to how you calculate the vacation leave. It's statutorily protected. I've set out or referred to Article 27.2, which has a carry forward provision, set out Articles 27.4 and 27.5, going over the page, 28.1, where employment is terminated. The employer shall pay an amount in lieu of vacation leave, and that is to be worked out by reference to the daily wage rather than the basic wage. I've provided the definition of daily wage as set out in Article 3 of Schedule 1 to the statute in paragraph 30. Wages is defined at the same point, i.e. Article 3 of Schedule 1, as all payments made in return for work. Working day, which is at the heart of the definition of daily wage, is defined again as meaning a normal working day. And clause 4, because it was before the weekend change, identified the normal working days as Sunday to Thursday inclusive. But clause 7.1 provides, unsurprisingly, that the claimant is entitled to the national holidays that are announced in the UAE for the private sector. I've checked, and there are 10 public holidays in the private sector. There were 10 public holidays in the private sector in both 2013, 2014. And therefore, the number of working days is therefore weeks times 5, which is the working days minus holidays. That comes to 250 days. And wages is to be equated with gross salary. That's defined in clause 2.1.5. You'll have seen that when reading through it, Your Honour. Paragraph 37.
But
Accordingly,
just before you go there, that's just maths there, but before you go there, paragraph 32.
Yes.
Should that read normal working day for the employee?
Oh, it probably should. My apologies.
I rather assumed it did, but I haven't.
I'm sure it does. Perhaps I can. If it doesn't, perhaps I can come back.
It's a point. It's a point of significance, not for this case, but for other cases where people have a lesser working week.
Yes.
That's why I asked the question. But
well, no, actually, I'm. My first thoughts and counterintuitively were right. because I'm looking at the DIFC employment law.
Yeah.
Working day means a normal working day for the employer as defined in the contract of
Oh,
employment.
yes, I see. Yeah. So it is the same effect.
It is the same effect, but I have to say it's slightly oddly expressed. One would have expected it to be perhaps for the employee, but yes, part-time working is an interesting point.
Yeah.
Fortunately, one which we don't need to investigate
Nope.
for present purposes. Paragraph 37, wages, gross salary. It's a matter of arithmetic. It comes out to 168,000. Then divide 168,000 by 250, and you're saved a lot of decimal points. In this case, it's $672 precisely per day. So that means that even if the annual leave for the 1st of August 2012 to 31st of July 2013 has gone, because he didn't take it, he remains entitled to receive payment in lieu of annual leave for the final year for 24 working days at the daily rate that we've now established, which comes to 16,128.
So stopping you again, the basis for losing 2012, 2013 is time bar?
No, it's because under the terms of
yes,
it's a contract of employment point.
Yeah, in the contract provides that you use it or lose it up to a certain point. Yes.
Yes. Yeah. And I've tried to look at precisely what the entitlement is. Then clause 10.4 says that shall be this is the entitlement point, and a failure to pay. Air tickets, claimant is entitled to be compensated, see clause 2.1.4, article 14 of the law of damages and remedies provides for proof of loss by current price, and I've set it out.
That can't be right. That can't be right, Mr. Patrick Joyce.
Well, it's there. It is there, Your Honour.
If he's lost the opportunity to take flights back in 2013 when EasyJet may have flown from Sudan to Dubai at I don't know what cost, it's hard to imagine that he gets anything other than the cost of tickets then plus interest. Anyway, there we go.
Well, yeah, and of course, cost of tickets plus interest may be a greater sum than current price.
Well, it might be, but that seems to me the logic requires it. I can't. You can address me when we come to closing on it if it becomes a relevant point. But on the face of it, just seems very odd.
Well, I must say, I had viewed it as, if you like, a mild penalising of the claimant rather than the other way around, in that if you're adding 9% per annum, which is the which is the statutory rate under Practice Direction 3 of 2017, if you're adding 9% over a goodly period of years, then I would have thought that the employer would choose to say, yes, current price, it's a bargain.
Well, I'll listen to what's said. I just find difficulty in it conceptually. It doesn't seem to me to be right somehow.
Well, all one can do is go according to what the law says.
That's okay.
End of service gratuity. We begin by looking at clause 12.1 of agreement 3, setting that out, then taking the court to article 62 in general terms at the foot of page 11. Over the page, quite a long extract from article 62, which the court will be fully familiar with. Paragraph 48, there can be no dispute that the claimant has completed continuous employment in fulfillment of the threshold requirement, which is article 62.1. And then the important point is how the calculation operates, because if one looks up the page, back at 62.2a and 2b, what is important is years or year of service, years of service and each additional year of service. And what we say is quite clearly, years of service is not coterminous with, nor is it delimited by the length of any fixed term contract of employment. Years of service is the aggregate period. In paragraph 51, we say that is an obvious point, and we say it's obvious for this reason. If an employee is promoted, hypothetical, employee is promoted and a new contract of employment is agreed, the effect of the promotion and the new contract cannot be to zero the years of service clock. And in essence, that's what happened, because the claimant was promoted from Networks Planning and Operations Director, his title and his job responsibility under Agreement 1, to Chief Technical Officer under Agreement 2, to Chief Technology Officer under Agreement 3. And years of service, we say, must aggregate the series of fixed term contracts, because a series of fixed term contracts is just as much years of service as they would be under one of a series of contracts of indeterminate duration. Now, the court will have at page 1481 the case of Furco, and I'm afraid I've misspelt it. It's Fernando rather than Fernando.
You're too much of an ABBA fan.
Well, exactly. I was thinking that I must have been listening to Mamma Mia too much. But it is Fernando, and it's a very short judgment. Begins at 1481, and at 1482, paragraph 3, claimant entered into an employment contract with, does the court have it?
Yes.
Yes. Yeah. Claimant entered into an employment contract with the defendant for a period of 1 year, with basic salary of X and housing allowance and transport allowance. Claimant and defendant, upon the expiry of the contract, agreed to renew it for 1 year, for 1 more year, from February 2014 to February 2015, etc. And then later, upon the expiry of the second contract, the parties agreed again renewed the contract for 1 more year. With changes to the basic salary and the various allowances. Just in case my learned friends is placing some reliance on the need for renewal, we say you don't need to use the form of words, well, we are renewing it, because what you're doing is you're simply rolling over and going on from Agreement A to Agreement B to Agreement C, or Agreement 1 to Agreement 2 to Agreement 3. And if that's what happens, that's what happens. And this was the subject of discussion. If one goes to the foot of page 1482, paragraph 10, first question to be considered is whether the contract between the parties is in continuance from 2013 to 2016. And then going over the page to paragraph 11, because of the renewals of the series of fixed term contracts, what the court finds is, therefore, the contract continued with the same terms for 3 years from 2013 to 2016, the change in salary and monthly allowance each year. As a result, I am satisfied to consider the 3 employment contracts as one contract starting from February 2013 with expiration in February 2016. As such, the discussion below will cover the period from the starting date of employment, etc. So we say, and then the way in which the end of service gratuity was worked through, you can see this from paragraph 15. What had happened was that there had been an attempted calculation of end of service gratuity at the end of each fixed term contracts, and a payment had been made, but because of the aggregation, sufficient payment had not been made, and that is spelt out in paragraph 15. And the court can be satisfied that it really was a rolling over of one contract to another, because if the court looks at the first agreement, which begins at page 791,
Yeah.
And let me just find particular, sorry. That's my apologies. I need to.
What are you looking for? Clause 15.1 at page 800?
No, Ron, I'm looking for yes, I'm looking at paragraph 14.4 for this purpose, which begins at which is found at page 800.
Yes.
And clause 14.4 on the first agreement reads, if during the course or after termination of employment hereunder the employee is offered any new employment, appointment or engagement, he shall, prior to entering into any related contract, bring the terms of this article 14 and articles 12, 17, 18 and 19 without further elucidation as to what that clause means. It is meaningless. But the reason why I take the court to a meaningless clause is because if one goes on to the contract which was entered into in 2010, one finds at 14.4, let me see, yes, at 14.4, and here it's rather odd because the contract begins at substantively at page 877, and the court has to go on to page 882, and the post-termination obligations in this contract have been renumbered and they become clause 11. But the renumbering goes awry when you go over to page 883, and it reverts to 14.2, and then 14.4 at the foot of page 883 is the same nonsense.
14, 12, I'm just looking at the clauses that are being referred to. Post-termination obligations, 12, 17, 18 and 19. 12, yeah, date of termination, 17, 18, 19. Confidentiality restraint. Yes, I see.
I'm not convinced that it's an exercise that can be done, Your Honour, but I'm not convinced for present purposes that it's an exercise that needs to be done, because the point that I'm making is the rolling over from one contract to another. We start off with clause 14.4 back in 2008. We then go on to 2010, and the substantive clause has been renumbered. But at the foot of page 883, we find 14.4 and the same gobbledygook.
Yeah.
There is another 14.4 over the page, but that's properly numbered. And then if one goes on to the 2012 2012 contract, beginning substantively at page 889, if I invite the court's attention to page 895,
it's the same point.
the same point. And again, it's misnumbered because it should be. It's appearing in clause 11, and there is again another 14.4 over the page at page 896. So is this a role?
Yes, what am I supposed to make of this?
Well, it's going back to the test in Furco and Fernando. It is a rolling over of the contract, and therefore they should be treated as one, certainly for the purpose of calculating the end of service gratuity
And what's the precedential value of a small claims tribunal decision on this court?
Well, it's persuasive. It doesn't bind the court, but we do say it's persuasive, and it's persuasive. Well, it's persuasive on two bases. One is the question has arisen before and has been adjudicated upon. There is an element of judicial comity, even with a lower court. It should only be departed from for good reason. And we've sought to test the good reason of the lower court in paragraph 51 of the skeleton by saying that there can't possibly be a substantial material difference between someone whose contracts are renewed because they were all of indefinite duration but get a promotion or whatever, and what's happened here. And what's happened here is on all fours with Furco. So going back to the skeleton for purposes of quantification, paragraphs 53 through to 57, work this one through. Started on the 1st of November 2008, continued until the 31st of July 2014. So we've calculated the service period. The basic wage this time is what's important. The basic wage was $11,000 per month. That annualized multiplied by 12 is 132,000. This one we have to divide by 365. It gives a daily wage of just over $361.64. I've spared the court all of the decimal point numbers, but then the exercise is you take 5 times 21, because that's Article 62(2)A, which was set out. That's the 21 days basic wage for each year of the first 5 years. And then the proportionate amount for the 6th year, which is 273 divided by 365 times 30 times the daily wage. And we've given the two figures, and the total is $46,087.29.
So the only difference in the present case between calculating this in relation to each of the individual contracts is that you get beyond the 5 years by however many months it is, 8 months or something, and get an upper a multiplicand of 30 instead of 21.
Yes, and also what Furco makes clear is that 2016 is the proper date for calculating the end of service gratuity.
Yeah, in other words, it wouldn't be right to pay it at the end of each fixed term contract.
No, that wrong step was taken in Furco, which went to mitigate the amount which was
Understood.
And then, Your Honour, if I may turn to payment in lieu of notice, which is page 14 of the skeleton. Clause 3 of Agreement 3 is relevant. Clause 9 of Agreement 3 is relevant, and Clause 18 is relevant. They're set out on pages 14 and 15. Top of page 16, those clauses must be read and construed together. And if D, the defendant, chooses to arrange its affairs in a particular way, then it suffers the obligations as well as the benefits, and may well be, having seen that there's income tax and corporation tax in Sudan, that it's very attractive to have one's headquarters in Dubai and the DIFC. But be that as it may, and here, taking first, this is the contractual position. There's an alternative statutory position, but I don't think we need deal with it to any great extent, because contract holds good. Clause 3.3 set out, I won't refer to it, read alone is, we say, stark and harsh, because it would mean that employment of any particular employee would automatically terminate without more, whether or not there was a need for the post or the need continued. Now, that is very harsh, very stark, and it's tempered, reading the contract as a whole, by clauses 3.4 and 9, because what 3.4 does is it imposes a mandatory obligation on an employer, or the employer, to pursue one of two alternative routes. Either before the end of the fixed term, either confirm or advise the date on which the fixed term was to end and the reasons for the fixed term coming to an end, or negotiate an extension if the work was to continue. So we say clause 3.4 makes it very clear that the contract of employment fixed term cannot just end by efflection of time. The defendant must fulfill one or other of the express obligations, which it itself has set out. This is the defendant's contract. Now, clause 3.4 doesn't set a time, but clause 9.2 says that in the case of fixed term employment, D may at any time terminate the employee's service by a 6 months notice. Now, what it's doing is terminating the employee's service. So this again goes back to the continuity of service point, which we've already seen. And it's quite clear in our submission that the claimant's service extended over the whole time span of the series of fixed term contracts. And if defendant intended to terminate that service, it was indeed required to give 6 months contractual notice, even if there was an apparent expiry by efflection of time. On the fact, on the terms of this contract properly construed, the mere fact of expiry is not sufficient and does not obviate the need for the defendant to give notice. So clause 9.2 provides the time frame for clause 3.4. Clause 3.4 also plainly requires the defendant to impart information. Clause 18.3 expressly provides for how that information is to be imparted. It must be in writing, and it must be communicated by one of the means itemized in that clause. Again, the defendant has written it, the defendant must comply with it. And what's more, I've given you the page reference, page 902. The defendant sent an email on the 30th of January, so we say it was clearly mindful of the need to inform the claimant under clause 3.4 and within the time set by clause 9.2. The trouble is, it was ineffective because it wasn't communicated by any of the means itemized in the clause, which are exhaustive, and it didn't follow, therefore it didn't follow its own requirements. So on that ground, the notice was invalid. But secondly, there was no confirmation or advice as to the reasons for the fixed term coming to an end in either a document of the 30th of January or a much later one on the 22nd of July. So the defendant failed to fulfill the requirement of clause 3.4b. The contractual consequences is that valid termination notice was not given. And in those circumstances, the defendant has the option of paying 6 months' salary in lieu of notice, That's clause 9.2. It must be taken to have exercised that option. By clause 9.3, notice pay comprises gross monthly salary. That takes one back to the definition we've seen in clause 2.1.5. That amount is $14,000, and $14,000 times 6 months, that's the monthly rate, comes to $84,000. The alternative is the statutory route. Now, the statutory route provides a 90-day notice minima, but we say we don't need to fall back on statute because we have the contractual provisions. Time for payment of wages simply indicating that this had to be paid within 7 days. It wasn't. Then we get on to the statutory penalty. Article 818 is set out. The defendant has failed to pay all the wages. The defendant has therefore failed to fulfil the statutory obligation set out in Article 18. It's therefore liable to pay a penalty, which is equivalent to the last daily wage. We've calculated the daily wage back in paragraph 38. It's $672 a day, and that was with effect from the 15th of August 2014. And the claimant has not made payment. The defendant has not made payment to the claimant. And I'm afraid time has ticked on. It's 3,180 days. Defendant had it within their power to stop the clock ticking by making payment. It hasn't. There's then a point which I may not need to pursue at all because it forms no part of my learned friend's skeleton argument. And we indeed say it's a diversion and a red herring, which is an alleged loan of 250,000 dirham made in October 2016 on the defendants, according to the defendant's pleading. But it really goes nowhere for the reasons set out in paragraphs 82 to 88. Then compendiously, we refer to damages and compensation under the DIFC law of damages and remedies, paragraph 89. Paragraph 90 claims interest. Paragraph 91 refers to the list of issues, which in my submission has been covered by the submission set out in writing, and the conclusions follow inexorably from what I have said, together with interest and costs. Your Honour, I did need to take, I hope it was helpful, a little bit of time on the law. I may have gone a little bit beyond the time as set out in the trial timetable. I don't think we're going to be dreadfully awry, and unless I can assist you further at this stage, it's what I would say by way of opening.
Yes, thank you very much, Mr. Patrick-Joyce. Yes, Mr. Doherty.
Yes, thank you, Your Honour. Of course, you've got my skeleton already, so yes. I don't propose to trouble you by speaking to the defendant's case at any great length at this juncture. What I propose to do really is to take 5 to 10 minutes to give you an overview of the points that we raise in EXPRESSO's defence, which should then hopefully set the scene for what you will come on to hear during oral evidence, and what you'll hear from me in a fair bit more detail, I hope, during closing submissions. As you'll have seen, I've set out in my skeleton, despite what one may think, given the length of time these proceedings have been before the court and the fact that one can find 29 documents in the statement of case section of the bundle. The facts of this case aren't particularly complicated. There are some differences of facts between the parties, but Your Honour may have gathered already where this case is more likely to turn is on the differing interpretations the parties give to those facts in the context of both the contractual provisions that they agreed and also the relevant provisions of DIFC law. The overarching point that we make in answer to these claims, to echo the language that was used by the Chief Justice when this matter was before the Court of Appeal, is that in pursuing this claim, which relates to events that occurred between 2008 and 2014, the claimant, we say, has been caught resting on his rights. And whatever the reasons for that delay, what the claimant is now seeking to invoke are provisions of the old employment laws, that's the 2005 law, as amended in 2012, that have long been acknowledged by both the court and the legislature in amending those provisions to have given rise to what I think you could fairly characterise as punitive and often unfair claims against employers in the DIFC. And no doubt the claimant's position in this case is going to be, well, the law is what it is, or at least what it was, and must nevertheless be strictly applied. And our answer to that is to say that that sort of point cuts both ways. Because in order to seek to invoke and strictly enforce what is a fairly draconian penalties regime under the old law, the onus is on the claimant to show that on a strict application of the same law, that the regime actually applies to him and that he has presented in-time claims for entitlements that actually attach to him under that law. And on that, we say that the claimant's case fails for a myriad of different reasons. And dividing it up slightly, first of all, we have the bundle of claims that arise under the first two fixed-term contracts, which relate to entitlements that, whatever way one looks at it, would have crystallised in, first of all, 2010 under the first contract, if not earlier, for reasons which I'll come to during closing, and in 2012 in respect of the second contract. And whilst we take issue with the specific heads of claim that fall within the scope of those actions, the fundamental problem in the claimant's case, given the 6-year time limit that applied under the old employment regime and that applies under the contract law, is that those claims were out of time when he issued proceedings back in March 2019. And that, we say, is largely the end of those claims. I hear what my learned friend says earlier about this line of cases on acknowledgement of debt. We say that doesn't really go anywhere, not in this jurisdiction. Those cases relate to specific applications of provisions of the UK Limitation Act, to sections 29 and 30. You can see that if you go up in the judgment. And I'll come on to this again in more detail in closing submissions, but what we rely on is the TIG case, so the industrial group case that was before the Court of Appeal relatively recently. It's at paragraphs 109 to 112 of that judgment. Unless we'd assist, Your Honour, I wasn't proposing to take you there now because I'm probably going to revisit that case on a couple of different points during closing. But if you want to know,
where is it in your skeleton?
The industrial group.
Yeah, just looking for the reference in your skeleton, that's all.
Yes, bear with me. Paragraph 64, A, we refer to it, and it's referred to elsewhere
Yes.
at paragraph 64K, and again at 90E1.
Yep.
And there are a couple of different points of principle relating to the penalties regime, how it changes in 2019, what effect that has on limitation provisions. But there's also a much publicised principle that arose from the industrial group, which was a claim seeking to import a concept of malicious prosecution into the DIFC when it doesn't appear in the law of obligations. And the point of principle really is that you cannot simply transplant something that exists, particularly a statutory provision in the UK, and say that that should apply by analogy in the DIFC because it's a common law jurisdiction. And so what my learned friend's answer on the limitation problem is to say, well, an acknowledgement of debt restarts the clock, and so these claims aren't out of time. Well, that's a UK statutory concept. It's not something which arises under the court law or the contract law, which impose a requirement to bring your claim within 6 years of the breach or the relevant events giving rise to the entitlement. And there's no workaround for those provisions in the DIFC. So actually, those provisions quite simply don't really get you anywhere on time. As I say, I'll go through that and walk through it in a little bit more detail in closing, but that's really the answer to that point. So claims under the first and second contract are out of time. No entitlements can arise there. For the sake of outlining the remaining defences that we say defeat those claims under the first and second contract anyway, just to give a bullet point outline again, largely.
Sorry, Mr. Doherty, I was making a note. Could you just repeat the point you were making? I was just making a note about the statutory provisions and so on. What was your next one?
So at paragraphs 109 through to 112 of the industrial group case, and
Yes.
that's at page 1524.
Yeah, I've got that. Yeah.
Yeah. What the court says is that the existence of a gap in the DIFC law as compared with the common law that applies in the UK is not something that is automatically filled upon the application of English law. The DIFC is built upon its own statutory framework, and one can't simply transpose concepts that exist in English law across the DIFC law unless there is a proper legal footing for those in the DIFC. And so the point in this context, when it comes to the acknowledgement of debt, although it applies in other contexts, is that you can't simply say that there are provisions in the UK Limitation Act which allow an acknowledgement of debt to reset the clock and transpose that to the DIFC when there's no statutory underpin in the DIFC for that sort of principle.
Yeah.
And you may have noted from my skeleton, I make the same point when it comes to out-of-time amendments to statements of case. So in the UK, under the Limitation Act, you've got a relation back principle that says if you have an out-of-time amendment allowed, it's treated as though it's made when it was first pleaded or when proceedings were issued.
With extraordinary detailed provisions in the White Book as to how you, when you give permission to amend in such circumstances.
Yes, and we say that regime doesn't actually apply in the DIFC as well. And so I'll come on to explain that argument in detail. But what we say
I don't need much persuading about that. Where you have a detailed system of rules in the English White Book as to how you get or don't, how you allow for the relation back theory, if I can put it that way.
Yes, and really then that comes down to the factual question of when was a penalties claim first pleaded. And I'm not going to go through the full detail of that now. It's partly set out in my skeleton, but I am going to go through it in some detail during closing submission because it's an important point.
Well, is it an important point? If you don't specifically plead the penalties point, does that mean you're deprived of it in any event?
Yes.
It's a point of law, isn't it? That follows from the, supposing you find, and this of course is the oddity about the whole idea, which is why the 2009 amendment was made. But if you pay 1 penny less than you're meant to pay within the 7 days following termination of employment, then you're liable to pay the penalty. And I can't quite see why it's absolutely essential to plead it in any event. It's a consequence that simply follows from the other claims, a statutory right that the court's bound to enforce, isn't it?
We say no, and the reason for that is again something which comes up in the industrial group case.
Right. Okay. Well, you'll continue to take me to that. And what I'd wondered was, because this is a point that's made in the evidence, whether there's any question of abuse of process that would in any way prevent time running on that. And I don't know whether the courts in the DIFC have ever grappled with that. I know attempts were made at various times to try and get around what was seen as an utterly unjust law, but I don't think any of them succeeded, did they?
there are different issues that have arisen out of this law. I don't think that the points that we rely upon have been dealt with and addressed. I mean, really, there are 2 points. There's the date of amendment point and how that interacts. There's if there is a decision on that issue which is relevant to this case in the industrial group case. So if I can dig out the reference. So there's discussion of this issue. Really, it's from paragraph 54 of that case onwards. So let me just get you the page reference for that. The industrial group is right at the back of the authorities.
Page reference, you got it?
Yes, I'm going to take you to paragraph 83 of the judgment, which I think is the most relevant bit. And as I say, there are a number of elements of this judgment which I'm going to go through in detail in due course. Page 1518. Apologies, I've given your lordship the wrong case. I'm actually referring to the Court of Appeal decision in this case at paragraph 83. So that's the authorities bundle. Perhaps my learned friend can help me. I don't actually see this decision in the authorities bundle, but it is referred to in my skeleton.
Yeah, no, I can certainly help the learned friend, and I was just finding the right page. It's not in the authorities bundle because it's in the main bundle, and I think the page number that the learned friend wants is 419, and the judgment begins at page 395. 393, 394 is the order. The judgment itself is 395, and paragraph 83 is page 419.
Thank you, I'm very grateful. And Your Honour will see this is the paragraph 83 beginning Article 1.3. Is to be read subject to Article 10. So this is talking about the application provisions of the 2019 law and how that interacts with the new limitation provisions introduced. So that was from the 6 years in the court law through to the 6-month limitation provisions. And it asks then, the question is, what aspect of Article 1.3 is subject to Article 10? It cannot be Article 1.3a because Article 10 does not in terms apply to rights, remedies, debts, or obligations accrued or incurred by any person under the 2005 employment law. So what that's saying is, if you have an entitlement, the entitlement arises under the old law. So that's the question of whether you have the substantive right. And then it says what the operation then does Article 10 have consistent with the language of Article 1.3? It says plainly Article 10 can operate in respect of that class of legal proceedings referred to in Article 1.3b as any legal proceeding to be commenced in respect of any such right, remedy, debt, or obligation. So what it's saying is that although your right to a penalty accrues under the old law, the procedural provisions, including limitation provisions of the 2019 law, can come to apply in respect of classes of legal proceedings which might relate to accrued rights under the old law, but will apply to procedural issuance of a claim going forward. And what the Court of Appeal judgment then says is that Article 10 thus imposes a bar against consideration by the court of any claim commenced after the coming into force of the 2019 employment law, which is brought more than 6 months after the relevant employee's termination date. Any employee who had not commenced a legal proceeding under the 2005 employment law within 6 months of his termination at the time of the 2019 employment law came into effect would not be able to have that claim considered by a court. Now, what we say about this is that if you had an accrued right, so in this case, an accrued right to a penalty under the old law, and you haven't brought it as at the in-force date of the 2019 law, even though you had the substantive right, you're procedurally barred from bringing it at the point in time that the 2019 law comes into force. And this is what the Chief Justice came on to say at the end of that paragraph. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights in order to gain the benefit of a claim of penalties which might accrue against the employer following termination of the employment. And so it's on that point we say that what the claimant comes to the court seeking is a strict imposition of a draconian penalties framework, and that we say it is then, if it's going to raise that sort of case, subject to the strict legal provisions about when the claim should have been brought. And we say that the claim is never actually brought. Well, technically it still hasn't been brought. It was pleaded for the first time in 2022 and subsequently in the most recent iteration of the claim. I'll take Your Honour, as I say in closing, through all of the detail of all of those pleadings and why we say that's the case. The short point really is that in the earlier sets of pleadings, when the claimant refers to penalties, what he's actually referring to is a section of a 2018 draft law, which is fines and contraventions, which exists in various different iterations of the employment law throughout time. The only time we get a claim for what one would describe as the Article 18.2 penalty is from 2022 onwards. And in fact, if one looks at the most recent iteration of the particulars of claim, that provision of law has been highlighted in green text, indicating that it's a new claim. And so we say, if you don't get the relation back principle, the point in time at which that claim has been brought is now, and we're entitled to our time bar defence that arises from the binding Court of Appeal decision in this case.
The paragraph, Article 18.2, appears for the first time in the prayer for relief at F. Is that right?
Yes.
That's in green, is it? I'm afraid I printed it off on a non-colour printer, but
If we, yes, so the
Yeah,
statement
I
case
can-
right at the back of the pleadings bundle and right at the bottom.
I'll look for it in due course. Yes, thank you.
And what you find at F is in red the reference to the Schedule 3 penalties. That was it said fines and penalties as per Schedule 3, and then it says as per Articles 8 and 9 of DIFC Employment Law number 2 of 2019, which again is a fines and contraventions provision, and that's scored out in red and replaced with under the DIFC Employment Law, in particular Article 18.2 in green.
Yes, I see.
So this is the point really which arises from a combination of what the court said in the industrial group was the nature of an accrued right to a penalty, and then the procedural effect of what the Court of Appeal has said in this case about the extinguishment of the right to bring that sort of claim if it wasn't presented before the coming into force of the new employment law regime, which fixed new, shorter limitation provisions.
Yes.
And so ultimately the point is that whatever else might fall as being an in-time claim, the penalties claim is not. And so one would simply be looking at the other entitlements that were pleaded on time. So that really that's answer number one to the claims that arise for penalties, largely under the third contract. There's another argument, Your Honour will noted, which is based on Article 4.1 of the Employment Law, as was amended in 2012. And what Article 4.1 says in 2012 is that the employment law only applies to a contract of employment to an employee based within or who ordinarily works within or from the DIFC. And again, in circumstances where the claimant comes to court seeking a rigid application of the penalties regime, he needs to demonstrate on a similarly rigid application of that provision that the penalties regime, or for that matter, any other statutory entitlement, such as notice, end of service gratuity, annual leave entitlement, and so on, actually apply to him. And there are a number of reasons for it, but we say it cannot because during this window of time, that's 2008 through to 2014, but given the limitation restrictions on claims under contracts 1 and 2, it's most likely to be under the third contract that's relevant. The claimant was not based in or working within the DIFC. As I say, a number of factors go to that. The first obvious one is he doesn't actually get a UAE residency visa until mid-2013. But even then, he's based in and working from Sudan, as well as traveling to operational fronts elsewhere, largely in Africa. And even then, when he is in Dubai, it's for the most part not the DIFC, because when he spent anything other than a short period of time in Dubai, it was actually based in a JLT office, which is where EXPRESSO is based for most of this window, so it's not the DIFC. And my learned friend may well say, well, there was an agreement that DIFC employment law would apply, but that isn't an argument that is open to the claimant, because the opt-in provisions, which allow those situated outside Dubai to contract into the DIFC employment law, isn't introduced until 2019. So you don't fall within the scope of the 2012 law, the 2012 amendments, by contracting in. And so when one removes the application of the employment law, because it can't apply on its own terms, the best that the claimant can get to is a contractual right. So it would be a claim under the contract law for contractual provisions that he agreed in each of the first, second, and third contracts. And Your Honour will have also seen that there's then the third element of that, which is another scope of law provision, which is that the employment law applies to employees. The defendant's case is that he was working as a consultant during this period. So what in the auto-cleanse English line of cases would be referred to as an independent contractor rather than strictly an employee. And each of those points get you to an answer that the statutory provisions don't apply, or at the very least, the penalties provisions within the statutory regime doesn't apply. As I say, those are the overarching defences. We do have something to say about the individual heads of claim, both on questions of liability and on questions of quantum. I don't propose to go through them in detail, but to give you a bullet point outline of some of those, the claimant's claim for unpaid salary under the first contract fails, not only because it's well out of time, but because there's no factual basis, we say, to support the existence of that entitlement when one goes back and looks at contemporaneous documents. The claim for shortfall in salary under the first contract fails because one can see on the facts and on documentary evidence that the first contract came to an end and was superseded by the employment contract with Sudatel in September 2009, and the consultancy agreement that was then entered into between the consultancy agreement that was then sent and we say acted upon by the claimant. The claim for airfare under the first contract, we say fails because there was no contractual entitlement to airfare at all in that particular contract. But the residual claims then in the second and third contracts for airfare and also annual leave fail because those are use it or lose it entitlements, which on the claimant's case he didn't use, and therefore he has no residual entitlement to payment in lieu. Similarly, the claim for relocation under the first contract, we say fails because in the factual circumstances of this case, the claimant never ends up relocating to the UAE. He remains based in Sudan. The claim for end of service gratuity fails under the first contract because it's terminated before the 1 year service requirements have been satisfied, and he assumes his employment with Sudatel as well. And that the remaining end of service gratuity claims, we say, fail because the claimant had no statutory entitlement under DIFC law, the reasons I've already taken you to, but these are also heads of loss that he appeared to be claiming from Sudatel for the same period, and those claims are inconsistent. And then under both the first and second contracts, whatever view one comes to about those heads of laws, there was no penalties regime that existed at all under the old law, by which I mean the 2005 employment law before the 2012 amendments introduced penalties provisions. So both of those contracts came to an end before the 2012 amendments, which introduced the penalties regime, came into force. So even if one was to find that there was some amount owing under the first or second contract, no penalties would attach to those because the regime didn't exist. And the final point, very briefly, relates to what my learned friend says about notice entitlements under the third contracts. And what we'll say about that is that the claimant is both wrong in his interpretation of what is an automatically terminating fixed-term contract, which is permissible under the 2005 law, because the 2005 employment law enables parties to agree to longer or shorter notice periods in a contract. That was changed in 2019, but not of the material time that these claims relate to. But secondly, he's also wrong in his interpretation of the supposed notice provisions of the contract, because what the contract simply says is that you'll be advised that your fixed term is coming to an end. And then the third point is that on the fact that's precisely what happened, because in January of 2014, the claimant is advised precisely that. He's told a fixed contract is going to come to an end in 6 months. And that's what happens.
Yes.
Your Honour, I realise that's racing through, but that's our
That's
defence in a nutshell. I'll speak to it in more detail in closing. But that should hopefully give you some background to some of the issues that are going to be raised during the course of cross-examination.
Yes. All right. Well, where are we time-wise? 10:45. Where are we meant to be on our timetable now?
Well, Your Honour, the next item is the evidence of the claimant, and
Yes.
that was scheduled for 12:55 to 14:25 GST, so 9:55 through to 11:25 here. And then we've got the slightly odd lunch adjournment where it's early here and late in Dubai, with the conclusion of Mr. MUSAAB's evidence after the adjournment, a short break, and then the commencement of the evidence of Mr. Aloub.
Yes. Well, we're 50 minutes behind schedule, so the real question is how you want to proceed from here. I'm personally very relaxed about how we work the timetable out. One has to bear in mind the court staff in DIFC. I take it you're both in the UK by the sound of it.
Yes, Your Honour.
And those instructing you are in Dubai.
Yes, Your Honour.
Yes.
Well, certainly, as far as I'm concerned, I think the same is true the case for Mr. Doherty.
Yes. Well, what's the most convenient course?
Well, I think maybe if we keep to the 6 hour time day, that would be, because it takes it through to 6 o'clock in the Gulf, and that taking account of the consideration of the staff, probably we shouldn't go beyond 6 o'clock, which would be 3 o'clock here. I'm again in Your Honour's hands as to how Your Honour would wish to proceed. I'm very happy to call Mr. MUSAAB. Well, I will call Mr. MUSAAB now. When we break is a matter for the court.
Well, I'm thinking of the court staff and the appropriate time at which they may still be able to, you know, for them to have a break, really. 3-hour time difference.
Yes, I think that was because the luncheon adjournment that we have on the timetable begins at 2:25 in the Gulf.
Yeah.
Well,
all I'm wondering is if, in fact, the sensible thing is to take a 3/4 of an hour break now, which would be a sensible time for lunch or more sensible time for lunch in the DIFC, and then press on after lunch with the evidence. But I'm pretty happy to run for an hour now if you think that makes sense.
maybe running for an hour would make sense.
From my solicitor's perspective, they say they're happy to take a 45-minute break now and continue at what I think would be 11:30
Okay.
our time. It doesn't cause me any issues particularly.
I think that's probably the easiest thing from the court staff's point of view. They get a more natural, something nearer their ordinary lunchtime.
Yes,
it's not
yes.
going to, you know, be a sensible time for us regardless. And then we'll take a short break at what is more like our lunchtime, just to, you know, for 1/4 of an hour or something.
Yes.
If that makes sense all round, and we'll play that by ear and see how it works. So we'll take 3/4 of an hour now, which means that we come back at, where are we now?
10:52. So 11.
Be around 11:35 or so, or 11:30.
11:35, which is 2:35 Dubai time.
Sure, indeed.
Okay, let's do that, and then we'll plan to have a 1/4 of an hour break later in the day, so that if you're starving, you can grab a sandwich or at least a cup of coffee.
Thank you,
Obliged.
Thank you very much. Very good. All right. So could he?
He switched on his camera. My witness is the claimant, Mr. MUSAAB.
Yes. All right. Can the witness be sworn in, please?
Certainly, Your Honour. Mr. MUSAAB, would you be swearing or affirming for today's hearing?
Yeah, I'll be swearing, yeah.
Yes. Do you have the Holy Book with you?
Yeah, it's here. It's the
Perfect.
Quran.
Yes. You please say after me, okay?
Yeah, sorry.
I swear by the Almighty God
I swear by the Almighty God
to tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Your Honour, the witness has been sworn in.
Thank you very much.
Okay.
Thank you, Your Honour. Mr. MUSAAB, just by way of the appropriate address, is it appropriate for me to call you Mr. MUSAAB?
Yeah, that's fine. Perfectly, yes.
Good. Mr. MUSAAB, I think you have the bundle of the hearing bundle available electronically, and
Yes.
I would ask you first to turn to page 441. 441.
That's okay.
Is that a document which is entitled First Witness Statement of MUSAAB Tag ELSIR ABDELSALAM?
Yeah, that's true.
And if I ask you to turn on to page 450, is there an electronic signature there?
Yeah.
Whose signature is that?
Yeah, that's mine.
And did you add that electronic signature to that page?
Yes, I did.
And we see the date there of the 1st of February 2023. Could I ask you to look back to page 445?
Yes.
Could you just read the very short paragraph 18 on that page?
Yeah, it
Well,
says
read it to yourself rather than read it out loud.
Yeah, it's all right. Yeah.
Are the contents of that paragraph true and accurate, or is there any change you would wish to make?
Yeah, there is a typing error there. The third agreement was executed on the 1st of August 2012, not 10. So that is just a typing mistake. Sorry for that.
Thank you, Mr. MUSAAB. Mr. MUSAAB, with that correction, were the contents of this witness statement true and accurate when you made them?
Yeah, to my knowledge, all of them are correct. Yes.
And do the contents remain true and accurate now?
Yes, they do.
Could I ask you now to turn on to page 459, please?
Yeah, okay.
That should be a document headed second witness statement of MUSAAB Tag ELSIR ABDELSALAM. Is that right?
Yeah, sorry, just 1 second, please.
459.
459. Yeah, that's the one.
Thank you. And if you go on to 468, is there an electronic signature on that page?
Yes.
Is that your electronic signature?
Yes, it is.
And we have a date for this witness statement of the 15th of February 2023.
It's correct.
I wonder if I could ask you to go back to page 464, because at the foot of that page is paragraph 26, which is quite a long paragraph, certainly longer than the previous paragraph I took your attention to, and it goes over the page to 465. I wonder if you could just read that paragraph to yourself.
Okay. Yeah, I would like just to highlight something, if you allow me.
Well, wait a minute. I think we can probably take it in stages. Is there a reference there to your passport?
Yes, there is.
And I think if you can turn in the bundle to page 980, I'll do the same myself, but in hard copy form. Correct. Getting there eventually. Yes. Looking at page 980, what is on that page?
Yeah, that's my passport first page. It shows my name and all the other details.
I see.
Yeah.
Yes. And I think if we look back one page at page 979, we can see that this is a copy of your passport, which the defendant company had because it's produced the document.
Yes, yes, exactly, yes.
And if we look at your name as set out on the passport, could you just read that into the record?
Yeah, it's given names, MUSAAB Tag ELSIR, which is MUSAAB, and then TAGELSIR, and surname is ABDELSALAM, ABDELSALAM.
And that, as I understand it, is your full and proper name.
Yes, it is.
Now, you make a point about the draft consultancy agreement having been made in a different name. Would you have expected the defendant company to have used your full and proper name, given that they had that available to them?
Exactly, that was my expectations.
But I think you do accept that the reference to MUSAAB Tag ELSIR Mustafa is a different, although incorrect, rendition of your name which had previously been used. Is that correct, Mr. MUSAAB?
Yeah, it has been used before. I realized that was used in Agreement 1 and Agreement 2,
Yeah.
but not in Agreement 3, which Agreement 3 uses the correct name on my passport.
Thank you. And I think the only other thing that I need to take you to is paragraph 28, and which is on the same page, 465. And again, just read that to yourself in particular. Well, just read it to yourself.
Yes.
And that refers to an attached exhibit. Because of the way that the bundling has been organised, and I don't criticise it, the exhibit is not in fact attached, and I think was not originally included, but is now to be found at page 1556 of the bundle. It should be the last page.
Okay. Yeah, I found it. Yeah.
And in terms of cross-referencing and page referencing, is what we see at page 1556 what you are referring to in paragraph 28 of your second witness statement?
Yes, that's my bank account statement. Yes.
Mr. MUSAAB, with those qualifications and explanations, were the contents of the witness statement that we're looking at, the second witness statement, otherwise true and accurate when you made it?
Yes, they are. Yeah.
And with the qualifications which we've read into the record, does it remain true and accurate now?
Yes, they do.
Mr. MUSAAB, would you stay there, because there will be further questions from the learned friend, Mr. Doherty. Thank you, Mr. MUSAAB.
You're welcome.
Thank you. Afternoon, Mr. MUSAAB. I just want to start with your first witness statement, which in paragraph 7, you referred to the first contract that you entered into. You say, pursuant to the first agreement. This is paragraph
Mr. Doherty,
7.
I think your camera's off. I can't see you. I can hear you, but I can't see you.
It's showing me as being on. Let me try and put it off and on again and see if that helps anything.
Ah, that's it.
Yes.
I'm seeing now Mr. Patchett Joyce. I'm not seeing Mr. MUSAAB.
No, I'm happy to turn my camera off if that would be more convenient to Your Honour.
I think so. That may just help, because then we only have two obvious speakers, and the cameras hopefully will reflect that. If you wouldn't mind, Mr. Patchett Joyce, and if you need to intervene, of course, you can always put your camera on again.
Has that helped? Is that sufficient, Your Honour? Can you see?
I can see you. I
Mr.
can't now.
MUSAAB.
I can't see Mr. ABDELSALAM, Mr. MUSAAB, but I expect when you ask him a question, he replies, "I probably will."
Perhaps it might be because I wonder whether it's a particular setting that you have on, which is to only have speaking participants
No,
come up.
We're there now. I've got both.
Okay.
Thank you very much.
Okay, thank you. Mr. MUSAAB, I was starting at paragraph 7 of your first witness statement. There you refer to your first agreement. You say your employment began on the 1st of November 2008 as Networks Planning and Operations Director in consideration of a monthly remuneration of 40,592 dirham. With that in mind, I just ask you to look at some of the provisions of that first contract. So first of all, if you could go to page 794 of the bundle.
Okay.
Where at the top of the page, you should find clause 2, headed remuneration. And it says, in consideration of the employee undertaking the employment, the employee shall be paid a monthly gross salary of 40,592 dirhams, and to be paid monthly in arrears to the employee's bank account in Dubai. And then clause 2.2 says the gross salary referred to above covers the following: basic salary, housing for employee and his family, school fees to the employee's children, and transportation allowance. Breaking that down just a little bit. First, referring to where it says you'll be paid monthly in arrears into your bank account. Presumably you would agree that your normal expectation would have been that you would have received your salary payment for each month for the work you've done previously.
Yeah, I expect to receive the salary by the end of the month, of each month, yes.
Okay. And do you agree that the salary that's being quoted there, so that's the 40,000 odd, is said to be gross? So it includes things like transportation allowances.
Yes, I agree.
Would you agree with me that in clause 2.2, when it's referring to what's covered, it doesn't say anything in these payment provisions about entitlement to air tickets?
No.
Thank you. And if we go further down the page, clause 3.1 and 3.2, it says the term of your employment will commence on the 1st of November 2008 and shall continue until the 31st of August 2010, unless terminated pursuant to clause 13. Your employment is for a fixed term, starting and finishing on the dates specified in clause 3.1, subject to either you resigning from employment or the company terminating your employment. So presumably when you entered into this contract, you would have understood that it was a fixed term contract. It was starting on the 1st of November and it was going to terminate 22 months later on the 31st of August 2010.
Yes.
Thank you. If we move forward to page 795, which is the next page. In the middle of the page, you'll see clause 6 titled annual leave, which says clause 6.1, the employee will be entitled to paid annual leave of 30 calendar days to be accrued within the first year of employment. It says 6.2, annual leave will be taken at a time agreed by the Chief Executive Officer by way of a leave application form, approved 2 weeks before the start of any leave period. And clause 6.3 says, the employee will not be entitled to receive pay in lieu of annual leave that is not taken except as approved exceptionally by the CEO or when employment is terminated. Leave accrued but not taken in any year shall not extend beyond March of the following year. And any further extension of accrued leave will be granted to the CEO's approval. Again, just to break that down a little bit, if one looks at clause 6.3, presumably you would have understood that if you're in your position for a full calendar year and you don't take all of your annual leave, then you lose it. It doesn't just roll over indefinitely.
My understanding is that if I don't use it, either by approval or by termination of employment, I should get the lieu, the payment in lieu of the annual leave.
Let's park the idea of termination just for a moment. Let's say we're talking about a situation here where you remain in your employment. I think my question is whether if after you've completed your first calendar year of employment and you don't use your annual leave entitlement, would you agree that what clause 6.3 says is that that entitlement will expire if you don't use it? It doesn't just continue to roll over for 1 year and then another year and so on.
Yeah, the leave itself will not carry on more than a year or so, as per the terms and conditions. But the entitlement for the payment in lieu has 2 conditions, as I stated there. This is my understanding in 6.3, either by the approval of the CEO or at the time of the employment termination.
Yeah, so I think my next question then is, again, parking the idea of termination for just a moment. If your annual entitlement does expire and you haven't taken the holiday, clause 6.3 says that you aren't entitled to receive a payment in lieu of that unless you directly agree it with the CEO.
Yeah, that's written there, yeah, of course.
And I presume you would accept that in the context of these proceedings, there's no evidence of there ever having been such an agreement between you and the CEO that you would receive payment in lieu.
Not written, yeah, not in writing.
Okay. So let me put it in a slightly different way. If you, let's say, work for a company for 5 years, and in the first 4 years, you don't use any of your leave entitlement, would you accept that you couldn't try and take all of those accrued days in your 5th year? So, for example, you wouldn't be able to take 120 days leave or 150 days leave in year 5 just because you haven't taken any leave in years 1 to 4.
Yeah, I think there is a difference between carrying on the annual leave and the payment in lieu of the annual leave accrued. So, of course, no, it's not possible to carry on, for example, 4 or 5 years and consume them at the 5th year. But the payment in lieu is subject to the specific terms and conditions of the contract. Another point, from my understanding, this employment has not been done through a single contract. So it has been done through 3 contracts of 2 years term each. And if you look at the, my understanding, if you look at the entitlement itself, it doesn't give entitlement for 2 years. It says the first year initially, because it assumes that the second year the employment will terminate or will end, and then the employee will not be entitled for leave. However, since the employment carried on and there was not a single day gap between the 3 agreements, that means the second year also is entitled. There is an entitlement for annual leave for the second year as well, based on the DIFC law. It's not possible for an employer to have an employee working for 6 years through 3 contracts of 2 years each, and then give entitlement for 1 year in each contract. That means he will lose 3 years of annual leave, and he will be working for 6 years, and in return he gets 3 annual leaves only. So my understanding, it's different from having continuous contract as one contract, and from the what we have now is 3 distinguished employment agreements of 2 years each, and this is why the clauses have been designed in this way. This is my understanding.
Just to come back slightly, I think you agreed with me that when it comes to your leave entitlement and the number of days that you're entitled to take. So in that hypothetical example where you've been working for 5 years and in the first 4 you haven't taken a day off, I think, would you agree with me, just breaking it down, first of all, when you get to the beginning of your 5th year, your entitlement going forward would be to 30 days. It wouldn't be to 150 days. You agree with that?
As I said, it's different from having single contract or 3 contracts of 2 years each. If it's a single contract, what you said might be valid. Now we look at 3 contracts with very clear terms and conditions. So the first year, there is entitlement for 30 days. And then the third, it's assumed that the contract comes to the end at the end of the next year. Okay, and then
yes, but just dealing on the scenario that I've posed to you. Let's say you've got a continuous run of employment, which is ultimately, I think, what you say in this case. At the beginning of year 5, you haven't used any leave. The accrued rights up until then terminate at the end of every year. And so when you're in your 5th year, do you agree that when you're planning your holidays, whatever it might be, that what you have is 30 days for year 5? You don't have 150.
By the way, it can be carried on even through the by the terms and conditions of this agreement, as if you look at 6.3 with the approval of the CEO. So it's possible, by the way, to have a leave carried on more than 1 year if the company both parties
possibly,
agree.
but
Yeah.
Let's assume that's not the case. When you start year 5, would you agree with me that you've got 30 days?
If it's through a single contract, unlimited contract, or not a fixed term contract, most likely what you've said is going to be the case. But now we have different case where we have 3 separate contracts of 2 years each. So I don't think it applies, the same concept.
So starting from that standpoint, you've got to your 5th year. you've got your 30 days entitlement for that year. Let's say your employment is terminated 6 months into the year. Would you agree with me that at that point, the entitlement to payment in lieu would be a maximum of 15 days? It would be the half amount that you've accrued for that 6 months.
Why? I don't know.
Well, at the beginning of the year, you've got 30 days entitlement. Let's say again, hypothetically, you haven't taken any days holiday, but 6 months into your 5th year, your employment's terminated. The entitlement that you have lost, you would say, is half of what your annual entitlement on year 5 would have been, isn't it? It's 15 days. It's not 135 days.
I don't think so. I think the entitlement itself comes at the end of the year. So at the end of the year, I get the entitlement for the 30 days. It's not a running window, yeah, if I can say, like, you know, a month and so on. So once it is entitled, then you got the time for validity, either set by the agreement or by the employment law.
Well, let's put it in your terms. Let's say you're terminated at the end of the year. Your entitlement then that you could claim payment in lieu of would be 30 days because that's the only existing entitlement you had, isn't it?
No, because the employment law says that an employee should get annual leave of a minimum of 20 working days for every year, for every year per annum. Actually, that's the word used, per annum. So even if it's not included in the terms and conditions of the agreement, the employment law maintains the right of this annual leave, and it's said also it's going to be pro rata. So if it's end of the year, then there will be, like, let's say 6 months, then it will be 30 days plus 15 days.
Okay, well, perhaps I'll give you one more question on it to put it this way, just so I really understand your case. You've worked for an employer for 5 years. At the beginning of your 5th year, you've accepted you had a 30-day leave allowance. Let's say 6 months into your 5th year, you leave and join a competitor for more money, let's say. Is it your case that your entitlement when you leave is to 135 odd days of accrued but unused leave rather than 15?
As I said earlier, first of all, it depends on the nature of the contracts. Is it a single contract or separate contracts, and the terms of conditions of each contract? Secondly, the agreement between the parties through the CEO and the employee, if they agree to carry on those entitlement, of course, they will carry on.
So what you're saying?
My point is that the employment has been for almost 6 years through 3 contracts of 2 years each. Each contract says there is an entitlement for the first year and kept silent about the second year, assuming that there will be no further extension or something like that. I think that's the rationale. I'm not sure about it. It's something of the law. So the court, the honorable court, and the councils can discuss that. But my understanding, if it's only the first year, that means intentionally the employer tried to prohibit the employee from having an entitlement for 1 year in each contract. So 1 year in the first contract, 1 year in the second contract, and 1 year in the third contract, which means prohibiting him from using his right for 3 years, which has been given by the employment law.
Okay, Mr. MUSAAB, I understand that.
I don't assume the agreement has been done in bad faith.
You must be aware that it's your case that you've been employed since 2008 through to 2014 continuously. So what I'm asking you,
through 3 agreements, that's the difference.
So what I'm asking you is whether you think that at the end of that, even though on your last year you only have an entitlement to actually take one portion of annual leave for 1 year, whether because you've left, you're now saying that, well, you can go back into history and claim unpaid entitlements all the way back since the beginning of your employment. That's my question.
Yeah. I can't answer it clearly, because if we say that we have a contract for 5 years, it will not have an entitlement for 30 days only. It will have entitlement for at least 4 years, if not the 5 years. And that's the point. This is what I'm trying to say. If it's a single contract for 5 years, the entitlement will not be only for the first year, for sure. So it has been like that because the contract is for 2 years. And then we got another contract of 2 years, another contract of 2 years. So this is the point. Different contracts have different treatment.
Okay, well, I think that's probably a point I can move on from, and I'll deal with later in submissions. If I can ask you to look at another provision, page 798.
Okay.
And clause 13.4, which is right in the middle.
Yeah.
There's some termination of employment. The company shall pay all wages owing to the employee within 7 days after the end of the pay period. So presumably, based on that provision, you would have been aware whether your agreement came to the end at the end of a fixed term or earlier. But if you had some outstanding amount due, you would have been entitled to claim that within 7 days of termination. Do you agree?
I should be paid, not only entitled to claim. It says the company shall pay.
Yes. So you were saying the point in time at which those amounts should have been paid to you was 7 days after termination.
After termination of employment. And again, this is the view of a single contract. If you look at the whole 3 contracts together, then the employment definition, I think, to my understanding, is the end of the whole employment service, which is 2014.
Okay. What you go on in your statement to say in the next paragraph, paragraph 8, first statement, is in breach of the defendant's contractual obligations. You say you received no salary from the defendant for 7 months between March.
Which page was that?
This is paragraph 8 of your witness statement. And if you want to look at it, it's page 442 and 443.
442. It's okay. Okay, so carry on, please.
442.
Yeah.
You're saying you received no salary from the defendant for 7 months between March 2009 and September 2009. And thereafter, you received between October 2009 and July 2010, only partial payment of 12,500 dirhams a month.
Yes, that's true.
So it's almost 30,000 dirhams less than you say you were contractually bound to receive.
Exactly.
Pausing there and again breaking it down. The first part of your allegation here is you've been put into a situation where only, I think it's 5 months into your new job that you started in November 2008, your salary apparently has stopped being paid in its entirety for an entire 7 months.
Yes, true.
So presumably, on your case, for that whole 7 months, you were having to get by, support your family, etc., without any salary at all.
Yeah, that's true. Yeah, absolutely.
And having looked already, as we have, at those provisions about you're expecting payment monthly in arrears, presumably you would have been expecting that constant flow of payment to be coming in every single month.
Yes.
Given that, and again, only 5 months into your new employment, as you put it, sounds like quite a serious scenario. You're not being paid at all. 7 months, more than half the total time that you say you were employed. Do you accept that you haven't provided a single piece of evidence that shows you ever contacting the defendant or its HR or its finance team saying, I haven't been paid for 7 months, where's my salary?
I have contacted all of them. Unfortunately, due to the time period, I don't have access to all the emails because those are company emails and the server gets updated every few years. So you don't get all the old emails. But for sure, I have been requesting payments of my salaries. And as you said, it's a serious situation where you stay for 7 months without having any income. So for sure, anyone will ask for his salary payments if it's not paid a few days later, let alone a few months.
Sorry, I'll just re-ask the question just to be quite clear on what I'm asking. Would you accept that you haven't provided a single piece of documentary evidence showing that you were asking for that payment to be made?
I provided documents to support that, but not in 2009. Later on, yes. I didn't provide a document to support that. I claimed those payments in 2009, but I provided documents for later claims. Yes.
Yeah. I'll hold that thought because I will come back to that.
Yeah.
If I can then ask you to look at page 859
Yes.
This is the draft consultancy agreement, which you've already been taken to. Sorry, can I just check, Mr. MUSAAB, are you still with us? Because your screen looks
Yes,
frozen
yes.
to me. You are, okay.
Yeah.
You're taken to this. I think you've confirmed that although it uses a different iteration of your name, it's still your name.
Yes.
And if you look at clause 11, we see a provision there. It says Expresso and consultant have agreed to bring Expresso employment contract to an end with effect 30th September 2009 upon the following final settlement of all entitlements due. And then there's a list of entitlements, but it's the first two bullet points under A. It says unpaid salary, not applicable. Gratuity, end of service benefits, not applicable. So do you see that?
Yeah, I see that. And this is why, I highlighted before that I believe this document is not relevant to me. It's relevant to a colleague of mine, because if you look at unpaid air tickets, it says 1.5, which is for 1.5 years. And even if you look at the annual leave, it says only 10 days, and I didn't consume any. Even this has been confirmed in the final settlement proposed by the defendant in all the emails, that my entitlement for the first year of the employment was 25 days. So I believe, and I put it in my witness statement, clarification why I believe this document is relevant to my colleague, Mr. Nazar Sahal, and not to me.
Okay, well, perhaps we can just explore that very briefly. Can you go back to page 858?
Yeah.
At the top of the page, you've already looked at,
Yes.
Mr. MUSAAB, ELSIR Mustafa, you've already accepted, I understand this morning, that is an iteration of your name, and that's also the name that was used in your first contract, correct?
Yes.
It says that you're a United Kingdom citizen, and we've looked at your passport,
Yes.
that's also correct?
Yes.
And if we look at the recitals that come underneath this, it says, whereas consultant was an employee of Expresso under a fixed term employment agreement dated 1st November 2008. So that's a reference to your first contract, and the date's correct.
Yeah. Yeah. The main point that I made it clear, I didn't receive that document, and I believe this document has been made later on, even most likely after I filed the claim before the court. That's my understanding. It's my first time to see it when the defendant filed this document as part of its defense. That's the point. I clarified that. I have been informed about the idea and the concept, which I rejected, and that's it. I didn't receive the document. So even this document, there is no proof or any evidence that it has been sent to me. It has just been filed as part of the defense. There is no email correspondence, a single correspondence stating that a draft consultancy agreement has been sent to me by the defendant. There is no single email that has been provided, no evidence of that.
Let me put my question about that section this way, which is, there's no evidence in the bundle, is there? No documentary evidence that you have ever gone back to the defendant saying that you don't agree that unpaid salary or end of service gratuity is not applicable, and that in fact you owe me 280,000 dirhams for my last 7 months' work. There's no evidence to that effect, is there?
Sorry, can you say that again, please?
So in this consultancy agreement, it is suggesting that at the time it's drafted, there is no unpaid salary and there is no entitlement to end of service benefits. And my question to you is whether you accept that there's no documentary evidence in the bundle from this time where you go back to the defendant and say, I don't agree with this. You owe me 280,000 dirhams for unpaid salary.
Yeah, because I denied completely that this document has been sent. And even if you look at the same point that you have raised, that no unpaid salaries, it says not applicable. It contradicts with the settlement proposals being sent by the defendant continuously after the termination of employment, confirming that those 7 months were not paid. And there was a proposal, even written proposal, from the defendant to pay the reduced salary of 12,500. So the non-payment of the 7 months has never been a dispute point, has never been disputed. It's how to be treated. That's the point, the main issue.
Well,
And again, I
let's-
believe that this document has been drafted after I filed the claim, and this is why it put like unpaid salaries. It's a defense mechanism. That's my understanding.
So you're saying this document's been made up. That's your evidence.
Sorry?
You're saying this document has been made up. You're effectively saying the document's been fabricated.
I'm not saying fabricated. I've said I believe it has been drafted afterwards, after I filed the claim before the court, because I haven't seen it before. It has never been sent to me. No even evidence, no single evidence showing that an email at least with an attachment has been sent to me. The content of this draft agreement appears actually to be for someone else. If you look at the air tickets and the annual leave. So my understanding, it has been made in a rush just to say that there was a consultants agreement and to base the whole defense based on that consultants agreement rather than employment. I can't say for sure it has been fabricated. I cannot do that, but I can say it's not irrelevant. I haven't received the document, and there is no evidence confirming that I have received the document. It has just a document. It's been attached to the defense without showing that when it was sent, when it was drafted. There is no evidence for that.
Okay, so your evidence is you didn't get the document, but you did just continue working for 7 months without pay. Presumably, it's your evidence you never threatened to resign. Haven't seen any evidence to that effect, certainly.
I highlighted before that the point of changing the employment into a consultancy has been raised by the defendant. And I said, I'm open to discuss any new relationship of engagement after you fulfill, as a defendant, the obligations under the first agreement, which says if the defendant wants to terminate the employment before the expiry date, it has to pay 6 months. And I've said, you terminate the agreement, then of course you have to pay 6 months, and then we go ahead with any kind of new engagement, which was not accepted by the defendant. They didn't want to pay, and they wanted to enforce a new reduced payment without my acceptance, which is clearly against the law. And even the employment agreement itself says any changes has to be signed by both parties. And that was never the case.
So just again, to pick up on something you've just said, what you seem to accept is that at this time, back when this consultancy agreement, what we say is sent, you say that there were discussions about changing the nature of your employment. So you accept
Yes.
that did in fact happen at the time.
Yeah, they informed me that you will be relocated to Sudan, and we will have a consultancy agreement in Dubai instead of the employment agreement. And I've said, if you want to do that, that means you want to terminate the first agreement, then you have to terminate it properly as per the terms and conditions of the agreement. You have to pay me 6 months, and then we engage in any new capacity or any new terms and conditions. And I believe that's even why they didn't send the agreement at that time, because I rejected the concept completely before being paid the relevant entitlements according to the first agreement. So they just try to put it as a fact, a de facto, like they just paid reduced salary, and that's it. And I still, after that, I kept talking to the management about this issue, and I asked them to recover it. And in July 2010, I got a new contract with a defendant, with a promotion, with a higher salary even than the first contract.
Okay, if I can ask you then to look in that context at page 916. Which is a document you were alluding to earlier.
Yes.
So we see an email from you where your name appears in the same format, just for reference as it did in the contract.
Yeah.
And here we are on 7th of March 2016, saying I have some missing items which were not finalized related to the contract termination entitlements of the first contract, in addition to the first 6 or 7 months, which haven't been paid by ETG. They sort this out. My question is simply, it's right, isn't it? The first record, first piece of documentary evidence that we have of you ever mentioning this issue is about 8 years after the event in March 2016.
No, it wasn't the first event. And as I highlighted earlier, all the emails that you see attached are from the company emails, okay? So the server keeps updating every couple of years. So you don't get access at that time in 2019, when I filed the case, I couldn't get access, let's say, to the emails 10 years ago, but I got the recent ones that I got are these emails. However, when the defendant sent the proposed settlement in 2014 after the employment termination, the main dispute was the 7 months non-paid and the 10 months of the unpaid salary, partial paid salary. So those are the major differences that we had. Apart from that, if I didn't raise those 2 points, then of course there should have been no dispute and there should have been full agreement about the settlement.
Okay, let's move on slightly then. Let's pick up on something you said earlier. If you could go to page 854.
Yes.
I want to touch on the second part of your allegation, because of course there are 2 parts to this. You're saying not only was I not paid for 7 months, but you're also saying I was only paid 12,500 dirhams thereafter. So that's almost a third of what you say was owed to you.
Yeah.
And so a few questions about that. So this is a document which isn't directly related to you, but you'll see at the top it says, due to the restructuring of EXPRESSO Telecom Group and its merging of operations within the mother company Sudatel, you'll be relocated to resume your work in Khartoum. In addition, you'll be enrolled under the management of Sudatel, effective 30th September 2009. You to contact as soon as possible the HR department to arrange a new contract. And now, I think you said that you were already aware of this. You were also a senior employee, of course. And given your seniority, it seems to me that you understood, am I right, that in September 2009, there was a restructuring, there's a process of relocation to Sudan, and the contracts were being moved across to Sudatel. Do you agree?
I agree that they were restructuring, that's true. And I agreed as well that the defendant proposed to me this new structure of consultancy rather than employment, etc., which is the company-owned decision. I said, I don't mind to discuss that. However, the current situation at that time, I was an employee according to the first employment agreement with a salary of 40,000 dirhams. And it was a fixed term contract of 2 years. It's if, according to that agreement, if the defendant wants to change it, or first of all, if the defendant wants to change the agreement, it has to be through acceptance of both parties in writing, which didn't happen. Otherwise, they have the right to terminate and pay 6 months in lieu, which they didn't do as well. So effectively, the first agreement was never terminated. However, the defendant intentionally tried to pay reduced salary to make it as a fact or a de facto, let's say, event.
Well, let's have a look at page 845 of the bundle.
Yeah.
So this is a document at the time of this restructure.
Yes.
This contract is made on the 1st of September 2009 between Sudatel and Mr. MUSAAB. The second party agrees to be appointed as planning division manager. The approved job descriptions and duties mentioned, plus any other duties, are signed by the president direct manager. And if you'll see at the bottom of this page, we've got the document being signed by 2 parties. Do you agree?
Yeah, of course. Yeah, I do agree. Yeah. Even
Yeah,
in the last
you
page, you see that I signed it on the 3rd of November, 2009.
Yeah, and if we go to page 846 of the page.
Yeah.
We find the same signature is first of all at the bottom of the page, but we also find reference there, amongst other things, to payment of salary and benefits. At point 2, to payment of annual leave of 35 days. At paragraph 5, that you're entitled to terminal gratuity payable on final termination of the services. So would you agree with me, first of all, that this is a contract between you and Sudatel?
Yes, I agree.
And do you agree that this was a contract between you and Sudatel which entitled you to amongst other things, salary, benefits, end of service gratuity, and annual leave.
Yes.
Do you accept that those are being described as employment entitlements rather than, as you put it, per diem entitlements?
Yeah, the practice, as I highlighted in my pleadings, that the practice at that time, because EXPRESSO main business is running operations, telecom operations in West Africa. So the Dubai office is the holding company office or the management office with no operations running in Dubai itself. So most of the staff, especially senior staff, used to have an onshore contract in the operation where they work, and in addition to an offshore contract in Dubai with EXPRESSO. So, and I highlighted the rationale behind that according to my understanding and so on. But anyway, that was the practice. So when the defendant relocated me to Sudan, it adopted the same practice, having a local contract to cover the local expenses, and an onshore contract, an offshore contract would remain in Dubai. Also, if you look at the first page of the contract, in you highlighted in page 845, it says the position is a planning division manager, and the area is EXPRESSO headquarters. It didn't say Sudatel Sudan or Sudatel or EXPRESSO Senegal or any other operation. It says the area is EXPRESSO HQ. And even the title or the position is almost the same title I had at that time. I was the planning director for EXPRESSO, and even the position here is almost the same. So it's just planning division manager. And in Arabic, if you look at the Arabic version, I know that you cannot read the Arabic at the moment, but just for record, the Arabic, it says that the translation of area is not correct in English, by the way, because in Arabic it says al-jiha, which means the entity. That's a literal translation, entity. And it says in front of the entity, EXPRESSO company, headquarters, very clear. So the entity or the area or whatever is being translated was never Sudatel Sudan. So this contract has been made on behalf of EXPRESSO very clearly to pay the local expenses during the relocation time in line with the defendant's practice during that period. And I don't know if it still carries the same practice on or not.
Could you go to page 851, please?
Yeah, okay, so right.
This is the translation of the signature page.
Yes.
See that?
Yes.
And so the name and the position of the person entering into this contract for the first party is the group CEO of Sudatel, correct?
Yeah, of course, yeah.
Yeah.
The contract with Sudatel, it has to be signed by Sudatel CEO. It can't be signed by EXPRESSO CEO.
Yeah.
And in this page as well, if you allow me, again, the position here is stated as Director of Planning Department, EXPRESSO headquarters for the second time. So it was not a typo or something like that.
If you go to page 852 as well, we have a translation of your benefits.
Yes.
Do you see that? So we've got salary, fuel allowance, car installments.
Yes.
Relocation allowances, taxes, and then over the page we have different provisions about annual leave. So, for example, fifth general conditions. So again, this is not a table of per diem benefits, is it? It's a table of employment entitlements.
Yeah, because there is no agreement or contract called per diem contract. So local expenses are covered through local contracts. That was the practice.
And if you could
The
jump forward,
main logic and the main rationale behind it is to cover the local expenses of the assignee at the location that they are assigned to during the period of the assignment. That's a concept, and that's the mechanism the defendant used to use in all its operations.
if you go to page 866,
yes.
I don't understand that there's any dispute about this, but perhaps you can just affirm that the benefits we've just looked at, those were paid to you.
Sorry?
Do you agree? You would agree. I don't think it's in dispute, or at least I'm not aware that it's in dispute. You accept that they were paid.
Yeah, I accept that they have been paid as shown in this statement, which shows the payments were only from October 2009 to September 2010, nothing before October 2009. So between March and September, nothing was paid. Even the agreement was signed in October, not before October 2009, not before that, not in March or any time before that. And there is no single payment being made after September 2010. So the allegation that the consultancy accrued or continued before that, beyond that time, is definitely invalid.
And then if we can go back to the consultancy agreement to page 858.
Yes. 858, yeah?
Yes, thank you.
Okay.
And we'd already started to look at the first of this series of recitals. So these are the sections beginning whereas right at the top of the page. So consultant was an employee, then it says whereas Sudatel, the parent company, decided to transfer the employment of the consultant pursuant from EXPRESSO to Sudatel under a separate employment contract, effective 1st of October 2010. And then it says whereas EXPRESSO and consultant agreed, the EXPRESSO employment contract would come to an end effective 30th September 2009 upon final settlement. Then it says whereas EXPRESSO desires to retain and engage a consultant in his capacity as an independent contractor to provide services. Now, I understand that your evidence that you didn't sign this agreement, but what's important, I suggest, for present purposes, that you were aware that the context, both in which this consultancy agreement was being proposed, and also that your Sudatel contract was being entered into, was because you were being relocated and employed by Sudatel.
No, first of all, this contract is completely, this draft consultancy agreement is completely irrelevant. Has never been served, as I mentioned, never, even there is no evidence that's been sent. Moreover, all the defense and all the, let's say, bleeding of the defendant, it confirmed that I have been relocated to Sudan by the defendant because I was working for the defendant. So Sudatel cannot relocate me. I was not working for Sudatel since 2008. So I was working for EXPRESSO. EXPRESSO confirmed that it asked me to be relocated to Sudan, which I had to accept according to the articles of the first employment agreement. It gives full right to the defendant to relocate the employee to any location that deems fit or necessary. So if I didn't accept to be relocated, I would have been in violation of the first employment agreement, and that would have given maybe the defendant the right to terminate for cause. So I had to accept the relocation. I had no other choice.
If you go over the page to 859, you have a look at what it says, clause 7 of this draft agreement. It says, for the services rendered, EXPRESSO's request and assignment of ownership rights in any work produced, inventions and or improvements by consultant EXPRESSO, a consultant shall be paid during the term monthly fees of 12,500 dirhams. So again, at this time, well, first of all, first question, I don't think you dispute that you received those amounts, correct?
No, I didn't.
No, you didn't dispute that you received them.
No, yeah, I did, and I don't still. I received those payments from October 2009 to July 2010. Yes, still.
Yeah. So in the context of your new employment contract at Sudatel, in the context of what you've told us you already knew at the time about the relocation and the restructuring that we looked at in that letter, you would have known when you received this 12,500 dirhams into your bank account every month that this consultancy arrangement was the reason that money was being paid to you.
No, I knew that the proposal for consultancy was there, which I rejected, and this is why I was expecting the defendant to comply to the first agreement terms and conditions to pay the full amount. It paid this amount of 12,500. Yes, it's a fact, but I didn't accept it. So I just highlighted that this is an issue, and I was in discussion with the defendant. Even I highlighted that after the termination as well.
Would you agree with me that there's no evidence in circumstances here where, in your case, you haven't been paid for 7 months, and then after that you start getting a third of your salary through every month? You haven't shown us any email or text message or anything where you go to the defendant and say, hang on a minute, I don't agree that I'm a consultant, I'm still your employee. Give me my 40,000 dirhams a month, not this 12,500 dirhams. There's no evidence to that effect, is there?
Yeah, it's just because of time, but I claim the 7 months which were not paid at all. I claim the difference of these salaries. And at the end of the day, the employer has the right to pay. I'm not the one who will force them to pay. So I claim, but they just paid what they wanted to pay. I highlighted that it's in total breach of the agreement. That's true. And the defendant was aware of that, but they kept doing it for 10 months.
It's also correct, isn't it, that the first time that we have any documentary evidence of you trying to claim this payment is the email we just looked at. So it's March 2016.
Yeah, I don't have emails before, like in 2009 or 2010. It's a company's email server. It's not mine. So to maintain the record for how long I want.
And presumably, if it is your case that you haven't been paid for 7 months, you're receiving less than a third of your salary after that, you're effectively, compared to what you say you're entitled to, living on a shoestring. Presumably, if you did ever raise this issue with the defendant, you would have been emailing them, texting them, phone calling constantly.
Yes.
Yeah, but we don't have any evidence to that effect.
Just because of the time duration, yeah. And the fact that they don't have access or control over the email server. It's all the emails that you've seen are my email on the company's email server. It's not private emails.
So your evidence is effectively you did chase this, you just don't have any of the evidence. Well, we've looked at the March 2016 email. If we could look briefly at page 913. This is perhaps relevant to something else you say in your witness statement. So to paraphrase it, in paragraph 9 of your statement, you say, I made several requests for payment, but the outstanding amount owed to me, but to no avail. But if we look at this email, 25th of February 2016,
yes.
So this predates the first documentary record we had of you asking for your 7 months and for your balance between the 12.5K and the 40K. What we see here is, dear MUSAAB, in connection with the audit of our financial statement, please confirm your account balance as set out below. Your early confirmation in this regards would be highly appreciated. So even in 2016, the only reason these amounts are coming up at all is because you're being prompted by the finance department following an audit.
No, as seen earlier, even in the emails on in 2014, there was a dispute. As I mentioned, I couldn't get very old emails from my side. So those emails has been provided, some of them by the defendant. Some of them I had access to them because they were recent at that time of filing the case, like 2016, 2017, etc. But the main dispute from day one in 2014 was the salary difference and the unpaid salaries. That's the main difference. If you look even at the figures about what has been proposed by the defendant and what I have claimed, the main difference or the main figures are coming from these two items. So if I haven't raised those 2 points before 2016, then there should have been no major dispute about the end of service entitlement since 2014, and we didn't need to have this kind of even email to confirm the balance.
Even just to catch what you said there, what you're saying is, well, even if I don't do the emails going back, I did send these emails in 2014.
Sorry?
So you're saying you did send these emails in 2014. That was a point of dispute.
Yeah, you know, the moment the employment was terminated, there have been several emails between the defendant and myself explaining the dispute points, what is the ground for those disputes, and so on.
Yeah.
So it's even the defendant didn't say that the defendant was silent or I was silent until 2016.
But that's 2014. That's still 5 years after you say that you weren't paid 7 months' salary and were paid a third of what you were due for another number of months. I suggest you they're simply not credible that if those payments weren't made and you were entitled to them, you would have been jumping up and down and shouting about it, wouldn't you?
No, I highlighted earlier. Of course, anyone who will not receive a payment or a salary, he will complain. And I confirm that as like any other employee, I complained about that. However, due to the time span, I couldn't access emails from 2009, 2010, and so on. And as I said again, the emails are not my private emails. So to make sure that I can maintain the records for 10 years or 5 years. So I was using the company email system, and which used to be updated and archived, etc., every couple of years. It's normal practice in most of the companies. And I was not allowed even to use personal email for official communication. So I was only using the company email.
All right, well, let's move on a little more in your statement. Paragraph 10, you talk about the fact you were assigned to work in Sudan from the 1st of October through to the 31st of July. You say to support Sudatel.
Sorry, which page, please?
This is in your first witness statement at paragraph 10, which is...
What is the page number, please?
Page 443.
Okay. Yes, go ahead, please.
So I don't think there's any dispute here, but you accept during this period of time you're working in Sudan as well as you had an operational role, so it's operations elsewhere in Africa.
I was still working for the defendant. I was relocated to Sudan. I was handling all my duties to the defendant. On top of that, I was assisting Sudatel with its new network design. And I was also responsible for a submarine cable business, which is normally not part of my responsibilities, but it was an additional assignment which I carried on for like more than 3 years, three plus, for the submarine cable.
Yeah, and then you say that whilst you're in Sudan, this is paragraph 12, if we continue down your statement, you say, I didn't use any of my annual leave entitlement or holiday air tickets throughout the first agreement. I didn't receive a relocation allowance.
Yes.
So on the first part of that. So on your leave entitlement, we've already looked at your Sudatel contract. Do you accept the Sudatel contract we've looked at? I can take you back to it if you want to look at it. So it's at page 846.
Okay.
Paragraph 2, if you want to look at it. My question is, during this window of time, when you're saying you didn't use your leave entitlement, you didn't use your holiday air tickets, do you accept that the Sudatel agreement contains provisions regarding annual leave and that your entitlement at that point of time was 35 days?
Yeah, that's what has been stated in the contract, but I didn't consume any annual leave, even with Sudatel. And even if you look at the payments receipt or slip provided by the defendant, it didn't include any leave of, it didn't include like any leave being taken. So I didn't take any leave, even if you look at it from a Sudatel perspective or from the defendant's perspective.
Yeah. So what I suggest to you is if you haven't used your leave entitlement, really that's a matter between you and Sudatel, isn't it? At least from September 2009 onwards.
No, because I was still employed for the defendant. I was just relocated to Sudan. I was, even the contract with Sudatel says the area or the entity that I work for is EXPRESSO HQ. So I was employed for the EXPRESSO for the defendant through the first agreement, which has never been terminated, and I didn't consume any holidays during that period or any annual leave.
All right, well, so you don't agree with that. You say on holiday air tickets that you were entitled there. I've already taken you to your first contract with EXPRESSO, and you agreed with me that your salary entitlements there were described as gross entitlements, and you accepted that there was no reference in there to air tickets.
Yes,
So my question there is, do you accept that if salary is gross, and that includes travel, and there's no additional provision for air tickets, that you don't have any basis for entitlement to air tickets in your contract with EXPRESSO?
No, I have, because the policy there at that time, because the contract included what we have agreed upon. On top of that, there were company policies, and according to that policy, I was entitled for business class ticket every year. And even if you looked at the Mr. Nazar Sahal document provided by the defendant, it shows that he has entitlement for business class ticket. Although he used the same contract that I used to have. So we had the same terms and conditions in the contracts. However, we were still entitled for air tickets. And so Mr. Nazar's document confirms that as well.
So just to be clear now,
policies approved by the company, I believe, are still obligations.
So to be clear now, you accept that there is no express obligation in your contract for air tickets. Your case now is that that entitlement arises as a matter of policy, not under your employment contract.
Yes, and also the employment law, I think, or one of the DIFC's laws, confirms that for an employee, there should be a ticket annually to go back to their home country. So apart from the policy and the contract, also I think the law mandates that an employee should be entitled for a ticket to their home country every year.
I suspect that's a position for Mr. Pratchett Joyce to.
Yeah, that's why I'm not. I'm just saying my experience. I'm sorry for going beyond. Sorry.
Can I just ask the last question to clarify? You haven't provided a copy of any policy which contains reference to air tickets, have you?
No. Again, that's due to the time span. But again, the company can deny if that was not true. And also, I refer to Mr. Nazar Sahal's settlement and documents provided by the defendant, which shows the air ticket entitlements.
Okay, paragraph 12, you talk about not getting your relocation allowance. I'll come back to some issues around this a little bit later. But do you accept that throughout the duration of your first contract, you never actually obtained the UAE residency visa?
Yes, that's true. And it was the responsibility of the defendant to issue the visa right after the signing of the contract. That's true.
And at least from September 2009, you accept that your role was based in Sudan, where you were relocated to. You accept that from at least September 2009, your role was relocated to Sudan.
Yes, for 10 months. But still, I was traveling and spending most of the time not in Sudan, not in, as I highlighted earlier. My role was to take responsibility of the defendants' networks, and all the networks were in Africa. Okay. Yeah. On top of that, our network suppliers were from different parts of the world, from Europe, from China, and so on, India, etc. So I had to travel for negotiations, designs, meetings, etc. And if you look at my travel statement, it shows that I have been traveling like every 2 or 3 weeks. And on top of that, we had the meetings for the consortium, submarine cable. We used to have an average of 4 meetings every year in different parts of the world. And on top of that, I used to attend international events for the telecom industry on behalf of the defendant in Europe, in Africa, and Middle East, China, Asia, and so on.
Yeah, so your point is that even if you're based in Sudan, you're also on the move throughout Africa to international business.
I was relocated to Sudan, but I was still moving, traveling to all parts of the world. Yes.
Okay. Well, just final question on that. Given you didn't have a residency visa, presumably you would accept that you didn't, indeed you couldn't have relocated to Dubai.
No, that was not the main issue for me. As I highlighted earlier, I had a bank account before joining EXPRESSO. So there was no issue of me receiving payments of salaries. And that's why the defendant was able to pay the 4 months salary from November 2008 to February 2009. I was single, and I was traveling a lot. So it wasn't a big issue for me to get the visa. With the British citizen passport, I was allowed to stay for continuous 30 days without a need for a visa. And I never spent, I think, more than 30 days inside Dubai or Sudan or any other country. I have always been traveling every couple of weeks.
Yeah. So you never relocated to Dubai, you didn't move to live there?
Sorry?
You never relocated to Dubai, you didn't move to live there? You didn't get a shipping container with
No,
all your possessions and send it out to Dubai?
Of course, I relocated. I took my possessions, I took my stuff there, of course, because that's what the base where I used to travel from, and that where I used to, our office used to be there. And I had an office, a cubicle office inside the defendant's office, where I had all my documents, all my files, etc. So I had a base there. That was my base. I had my luggage, I had my documents, I had everything in Dubai. I had my office there, dedicated to me, and I was traveling from there. I had meetings there, whatever, whenever I needed to. So my base, even my address, my business cards, everything, my contact was UAE number. I wasn't using any mobile number or phone number from another country. I was using Dubai office number, mobile number provided by the company. Since 2008,
it's the Dubai office, it's the Dubai mobile number, it's the Dubai
mobile number
address.
I mean, my
what I'm saying
number.
is you didn't relocate, you don't have a home in Dubai. You were basing yourself, you say, in your office, but from September 2009, you were in Sudan and then traveling.
No, I relocated, of course, despite the fact that one of the preconditions for me to relocate was to receive the relocation allowance, and it didn't happen. So that was another reason, by the way. However, it wasn't a blocking point for me. That's what I'm saying. I didn't receive the relocation allowance. I still carried on. I didn't receive the visa. I carried on. I didn't receive some salaries. I carried on. I never stopped working. I have always been very committed to my work, my responsibilities and my duties. So I was always seeing those as an issue, as issues which should be resolved, and I've been always talking to the defendant to resolve it. But I never stopped working unless those issues are resolved. So I was always working in a good faith. And they were serious, you know, not having salary for 7 months. It's not an easy issue.
I'll circle back to that issue later because I do have quite a few questions for you on it. But just taking this in sequence, moving to your claim under the second contract, you say that you're entitled to be paid for annual leave that you didn't take, and again for air tickets that you didn't consume.
Which page is that, please?
This is your claim under the second contract.
Yeah, which page, please?
So if you want to look at your first witness statement. We're dealing with issues that you're talking about at page 444.
Okay.
But I'm not asking you to look at a specific point of your witness statement at the moment. I'm going to ask you to have a look at some of the provisions of the contract.
Which number? Which clause number, please?
So first of all, go to page 878.
878.
Yeah.
Okay. Yes.
And these are the contractual provisions listing a number of your entitlements, so salary, allowances, education, living allowance, that sort of thing.
Yes.
And the first provision I just want to ask you a couple of questions about is clause 2.1.3.
Yes.
This deals with child education schooling allowance. It says it's granted once a year for a maximum of 3 children under the age of 18. And it says the annual maximum tuition per child is $5,000. See that?
Yes.
So just in terms of how your contractual allowances work, here you see the provision is talking about the maximum amount of tuition you can get. So would you agree with me that if, for example, your tuition per child is less than £5,000, you would only be entitled as an employee to claim that amount and not the maximum 5,000?
I agree.
So in other words, you're recovering what you've actually used.
I'm recovering what has been stated in the article. It says you get up to a maximum of that amount. If the article says something else, I'll be entitled to something else.
Yeah.
So I'm very precise.
And so where we're also talking about, tuition per child and a maximum of 3 children.
Yes.
If you've only got 1 child, you can't claim 15,000.
Exactly. Yes.
Yeah. And so if you don't have any children at school and you aren't incurring any tuition, you don't get anything.
And that was my case. So I didn't claim, I didn't get any schooling education fees allowance at all.
Yeah, okay. So let's just by analogy look at what it says about air tickets. So that's clause 2.1.6.
Yes.
Same page. The company will provide you with round-trip air tickets to you and to your family members, spouse and children in business class once every year to travel to your home country. So a couple of things. Do you agree with me that there's nothing in there which says that you get a fixed financial amount towards air tickets?
Yeah, the entitlement is for the tickets itself. And later I claimed a money in lieu of the ticket value. So the entitlement for air tickets, yes.
And that provision, similarly to clause 2.1.3 that we've looked at, can depend, amongst other things, on your circumstances. So I presume you would accept that if you didn't have a family at the time, you can't claim air tickets for your family that doesn't exist.
I don't think the two clauses are similar. First of all, the first one was setting a maximum. In the 2.1.16, there is no maximum. If my family members were 10, then I should have been entitled for that. So the first one was putting a cap for the education allowance. The second one, there was no cap at all.
No cap. If you had 10 children, you get 10 flights. But my question is slightly different. I'm saying if you don't have children, you can't claim flights for 10 children, for example.
If I don't have children, I will not claim tickets for them, of course.
Yeah.
And this is why I claim, I
so the point is,
you
can only claim something if you've actually used it.
No, I claim what I'm entitled to. This is a tricky point. I'm very careful about this. I would like to say, if in the education allowance, I'm entitled to a maximum of 3 children. That's the entitlement, okay? Again, I'm entitled for tickets for my family. So if I have no family, then I will only be entitled for myself. And that was the case for me in the first contract and the second contract. I claimed tickets only for myself because I was single.
Now, the question really is that this provision is expressly said to be subject to whatever your circumstances are. So if you've got a family, you claim for a family. Here, as you've accepted, your role has been relocated to Khartoum. So in those circumstances, you didn't use air ticket allowance to travel to Khartoum because you were already based there.
Actually, this is another point because the first agreement, it states if the company relocates me to any location, it has to support my displacement in accordance with my status within the company, which didn't happen. The company did not pay anything even to relocate to Sudan. And the company did not even claim till now that they paid anything for this displacement, although the company was obliged to pay for the displacement. So there's another point. I didn't claim in my particulars of claim, but I was entitled to get displacement amount in accordance with agreement 1, but I didn't claim it.
Well, perhaps let me put it this way. I'd suggest to you, Mr. MUSAAB, that the reason that you don't use air tickets to return to Khartoum are because you've already been relocated to Khartoum. You don't need a flight from Dubai to Sudan.
No, of course. And as I mentioned, if the company keeps relocating someone every year to one country and then to another country, there will be cost incurred by the employee for relocating from various countries. And according to the contract, the company should always compensate the employee for the relocations and displacement, because it's the company's decision to move the employee, and then it has to cover his expenses for that relocation, which didn't happen.
Yeah, and really, I suppose this is a relatively straightforward question. Do you agree with me when you look at clause 2.1.6, which hopefully you saw in front of you?
Yes.
There is nothing there that says if you don't use your tickets, we'll give you the equivalent value in lieu.
It's another clause, as has been deleted in my articles of claim, but even 2.16, it didn't say if you don't use it, you lose it. So there is another article or another clause specifying exactly how unused tickets or annual leaves and so on are used. That's my understanding. And also, I believe there is an issue, a point in the law of damages and remedies, also looking after such kind of claim.
Okay. Can we go to page 819?
Okay.
Have you finished your questions about air tickets, Mr. Doherty?
I have a couple more questions which are on the question. They're on air tickets. I'm going to circle back to some of the flights in more detail a bit later. So perhaps I can just ask those couple of questions, and then we're going to come back to this document. I assume this is for the purposes of taking a break.
No. It was because I had a question, but I'll wait till you finish your questions on all of this, and then I'll ask.
Okay, thank you. Mr. MUSAAB, I am going to come back to these documents in a little bit more detail later on, but this is just for present purposes on air tickets. So if you look at 819, we can see examples of some flights that you were taking during your second contract. So for example, we can see it's the entry 8th of August, but it seems to be in relation to flights from July and August 2012.
Yes.
We can see there are flights from Dubai to Khartoum, Charles de Gaulle, that's CDG, to Dubai. And we see similar sorts of travel. So if you go over the page to 820, I think again in the middle of the page, we see reference to DUB. So again, there are some flights to Khartoum, but there's DUB, which I think is Dublin. Again, if we go over to 822, again, flights Khartoum to Dubai, but in the middle of the page there, we've got, for example, Dubai to Madrid. And really, this is just to put into some of the context of what you've said. Is your evidence that all of these flights that we're looking at now, are these all work-related, or is some of this personal travel?
All of them are work-related. As I stated earlier, I've never taken a holiday. And most of the flights to Europe either were for a meeting with suppliers or for the consortium. So like Madrid was for the consortium, Barcelona was for an international event that we attend every year. Charles de Gaulle was meeting with France Telecom as part of the consortium of the submarine cable and so on. Also, I would like to highlight one important point. I have managed only to include the flights on Emirates Airlines because through the Skywards, you get the statement. However, some destinations, we used to take other airlines, like because Emirates didn't have direct flights, or sometimes you don't get a ticket. The flight is fully booked and so on. So we used to have some flights over Qatar Airways, Turkish Airlines, Ethiopian Airlines, Egyptian Air, and so on, Egypt Air, and so on. So what you see,
so for example, if you were in Khartoum and you were traveling internally within Africa, you might not go via Dubai, and it might be a different airline.
No, sometimes, most of the time I go through Dubai because I always go back to the office. That's the key point. I work for the company. The office is in Dubai. My office and documents are in Dubai. So I had to go to Dubai regularly. That's my workplace, even according to the 3 employment agreements.
So I think really the question I have is, you're saying this is all business travel.
Absolutely, 100%.
And again, this is just for my information more than anything. Is your evidence that you paid for these flights?
No,
or
all
did the
those
company
flights have
reimburse
been
you?
paid. No, all those flights has been paid by the company.
They've all been paid by the company?
Yes, it's business flights for the company, so the dependent paid for it.
Okay. So for example, as we see on 822, you'll see 27th of February 2012. See that? Flight Near East, Khartoum to Dubai. And then at the bottom, it tells us the date, 17th of February. It tells us that this is a business class flight. So your evidence is that that flight, which is a business class flight from Dubai to Khartoum and back, is paid for by the company.
Yes, because the policy at that time, according to the first and second contract, I think most of the third contract as well, half of it, the policy was to fly on business class for the executives, like myself and other colleagues.
I'm just writing that down. Thank you.
Yeah,
Your Honour, that's where I'm pausing on that issue for now. As I say, I'm going to come back to that if you have a specific question about air tickets.
I just had one question for you, Mr. MUSAAB, and it's this: what's referred to in this provision is for a flight to your home country. What did you regard as your home country at the time?
at that time, my home country was Sudan.
Right.
Now, yeah, it's all right.
So, and would that be true throughout most of the period we're talking about?
Yes.
Between the whole of the time of these three contracts?
Yes.
Right. Okay, thank you.
You're welcome. So, sorry, we can't hear you, Mr. Stephen Doherty. No.
Yes, I put myself on mute, sorry.
Right, that's fine. Thank you.
Just moving on to a slightly different topic. Paragraphs 23 and 24 of your first witness statement, you talk about provision of notice to end your employment under the third contract. That's if you want to look at it, it's a page 446. And you also deal with this at your second witness statement, paragraphs 31 and 32, which is at, if you want to look at it again, 466. But in essence, what you say is that the defendant failed to give you notice that your fixed term would come to an end. And so you say you're entitled to either 6 months notice under the terms of the contract, or you're entitled to 3 months notice under the DIFC employment law. The first document on that issue I'd like you to look at is page 897.
Isn't this really an argument of law, Mr. Doherty?
There are, well, I suppose there are minor factual issues within it. I'm not necessarily going to go through what the notice requirements were. I'm going to go through the factual issues that touch on that, and then obviously they hold over the rest for submission. But it's clause 18.3, which is the provision you rely on. So this is all notices required to be given or information supplied should be sent by hand, copy sent to registered post in the UAE, through notary public in the UAE by registered post, etc. So that's what you rely on.
Yes.
If you look just below that, do you see at the bottom of the page? It says MUSAAB tag, ELSIR ABDELSALAM, address blank, telephone blank, facsimile blank. So do you accept that you haven't actually provided any details in your contract to where notice could be sent?
No, the company has and had actually the information about my address and so on. And the same applies, by the way, if you see in some of the agreements that the passport number was not included. That doesn't mean the company wasn't aware. The company always had a copy of my passport. The company issued health insurance cars for me and for my family. And I have uploaded also the copy of the rent contract for the residence which I used to live in.
That's all well and good, Mr. MUSAAB, but you, on this particular issue, are relying on what you say is a strict and necessary notice requirement that appears in a contract that you should have been sent to your address or to your, using the telephone number designated, etc., notice of termination. And the question really is that you haven't actually, in this contract, provided any details of where that sort of notice could be sent to. Do you agree?
Yeah, not at the time of signing the agreement, but the company has my address, my phone number, my fax email, everything. Yeah.
Your email address, they have that.
Yeah, email address, of course. Yeah.
Yeah. Okay.
By the way, one point to highlight. I had my residence visa before when the third agreement expired, and the part of the employment visa is to have a residence, so the address was there, and the employment visa is always applied to through the dependent, so the company applies for the residence visa, so they have the documents. Absolutely.
Okay, and just very briefly looking at page 890.
Yes.
We have the provision again that you rely on, paragraph 23 of your statement, that says, prior to the end of the fixed term, company will confirm or advise to you the date on which the fixed term contract is to end, confirm or advise to you the reasons fixed terms coming to an end, or negotiate an extension. Do you agree that, perhaps a bit pedantic, but the word notice doesn't actually appear in that provision, does it? It just says we're going to be advised.
Yeah, confirm or advise, yes.
Yeah, and if you look at page 902,
yes.
We have there an email sent to you on the 30th of January 2014. MUSAAB at EXPRESSOTelecom.com, and it says, Dear MUSAAB, reference to fixed term offshore employment contracts with EXPRESSO Telecom, Sudatel, and EXPRESSO Telecom wish to inform you officially that the fixed term contract will come to an end the 31st of July 2014 without being renewed. In due time, Sudatel Group HR will prepare a contract for you. Should you have any queries, don't hesitate to ask. So on the 30th of January, 6 months before your contract was due to terminate, you are, in fact, emailed and advised that your contract's going to come to an end on the 31st of July, correct?
Yeah, I saw this email. I don't recall receiving it because I don't see any response provided, but I'm not saying that it hasn't been sent. So since they provided, I assume they have sent it.
Yeah.
I just don't recall receiving it or replying to it. And no reply has been attached. But yeah, I assume since it has been provided, I don't assume that they fabricated. Yeah.
Yeah, but here you are in January, an email is sent to you telling you that you're not going to be, that EXPRESSO decided not to renew your contract. And just on the question of that email address, if you go across 2 pages to 904, this is a document that you exhibited to your original particulars of claim at Exhibit 2. But you see there that the email address being used is identical to what we've just looked at.
Yes, yes.
So that would mean that you were receiving emails at that address.
Yes.
Okay.
This is why I said I'm not assuming that they fabricated, but I didn't see any reply. So it might have been sent, not seen by me or not read and so on. But since it has been provided, I assume they have sent it.
Okay,
Whether or
different issue relating to your employment proceedings in Khartoum. You refer to those in paragraph 22 of your first statement, and what you say is that the period for which you filed a claim does not cross over with the period in this case. Just on that issue, could I ask you to look, please, at page 965, which is a translation. It's dated the 21st October 2018.
Yes.
It's your amended statement of claim before the Khartoum Labour Court.
Yeah.
And first of all, can you look at paragraph 1? It says, my agent, the claimant, was working with the defendants in September 2008 up to May 2017. And the last monthly salary for him was £36,000 and $5,000. You
Yes.
see that?
Yeah, of course.
So it appears in this statement that you're asserting that you're employed by Studitel from September 2008 onwards, correct?
No, this is an introduction to show the court there that I worked for the Studitel and its affiliate, which will be explained later on. If you see in the other articles, you will see the explanation. And I didn't claim in the same document, you will see that I claimed only for entitlements after 2014, after September 2014. If you look at Article 9, all these points which I claimed, the compensation for arbitrary termination, unpaid salaries, entitlement for salary as of assigning of duties of director of network sector, okay, end of service gratuity, attorney fees, etc. Those are explained in Articles 6, 7, and 8, respectively. So in Article 6, I said the defendant did not pay my agent, That's my lawyers mentioned that his salaries with US dollars since August 2016 to May 2017. Nothing was before 2014. And even it shows the same amount, which is 153,000 SDG and $46,000 as shown in Article Clause 9A. B, sorry. Again, if you look at 7, Clause 7, the claimant is entitled to the assignment of additional job from, in the second line, from 9 of August 2015 to 20 September 2016, which is definitely after the employment with EXPRESSO. And the same amount is exactly identical to the amount claimed in point C, Article Clause 9. And last one in 8, Clause 8, the claimant shall be entitled for end of service gratuity. This is in relation to Sudan. And it has the two components, SDG and US dollar, which is exactly this relevant to the salary in Sudan after 2014, which was 36,000 SDG plus $5,000. So everything has been claimed here is only for the period after 2014, September 2014. The first clause was to give the court a history or an introduction that I have been working for the company, including its subsidiary, EXPRESSO, since 2008. But I didn't claim any single item before September 2014.
Well, I wanted to explore that with you a little, because you'll have seen what you said in paragraph 1. Your monthly salary was £36,000 plus 5,000 US, yes?
Yes.
And my understanding from the documents we have in this case is that when you claim end of service gratuity in Sudan, it's not dissimilar to how it works here. Depending on your length of service, your end of service gratuity is calculated in a similar way. You get something like 1 month per year of service.
No, Your Honour, I'm not too sure where this line of questioning is going, because it seems to depend on the law of Sudan, as to which we have no evidence.
Well, can we go? I can take you to page 948, which is how it's pleaded,
Okay.
and where I've got this from.
Let's wait and see, Mr. Patrick Joyce.
So if you go to page 948.
Yes.
And paragraphs, so this is its subject, complaint of the worker, and that's you, paragraph 3. Subject to social insurance law of 1990s, entitled to 1 month's salary for each year of service, end of service gratuity. So that's the legal basis, without me having to get into issues of Sudan law. That's what's being claimed. And if we then jump back to page 966, which is what you were looking at.
Yes, I can explain that.
At paragraph 8, the end of service gratuity that you are claiming seems to be 11 times
Exactly.
your monthly salary, which cannot be an end of service gratuity entitlement from 2014 through to 2017, not on your pleaded claim.
I will explain that, and I have already did explain this in I think in the reply to defense or one of the documents. I don't know which one exactly, but I can find that for you. I was the chief planning officer for Sudatel, which is a senior level. It's just right the second level after the CEO. I was reporting to the CEO, and all the executives, top management of the company, all their contracts were private contracts. They are not standard employee contracts. And as part of that, there was a different treatment for executives, whereby the company pays all the national insurance contribution, while in the normal case, the company pays 17% and the employee pays 8%. So there was a special treatment for that. And even there was a special treatment for end of service for the executives, top management. The policy was to pay 4 months salary for each year of service. And exactly it's 11 months because I calculated from the 1st of September 2014 to May 2017, which gives 2 years and 9 months. So 2 years times 4, you will get 8 months, and the 9 months, it's 3/4 of a year. So you get 3 months out of the 4 months entitlement. So in total, it's 11 months. And that's multiplied by the 36,000 SDG, it gives you the 396,000, and multiplied by $5,000, it gives you $55,000. So it's 100% in line and only related to the employment in Sudan since September 2014.
Well, Mr. Musab, I'd suggest to you that what your claim actually says is that you're claiming under the 1990 Social Security Act, and what you've expressly sought is 1 month for every year that you're in service. So I suggest to you that actually what you're doing in this claim is seeking to claw back end of service entitlements for a period from 2008 onwards, it seems.
No, this is the based on the 1 month is the standard policy according to the labor law. However, if there is a contract agreed by 2 parties or a company policy, it of course it will supersede and it will apply. So for normal employees, yes, but for top management, even our contracts were different from the normal employees. It was a special contract. They used to call it private contracts. And even if you look at the appointment letter, it was sent to the board secretary. If you look at that, because top management, all private contracts used to go to be approved by the board of directors, not only the HR.
Yeah, well, Your Honour will be pleased here. I'm not going to get into deeper issues of Sudanese law. I'm going to move on to a slightly different issue. Very, very briefly, one can take a view it's not directly an issue, but there are points that need to be addressed within it. So, Ms. Musab, I'm not going to ask you about this at any length, but in your first statement, the paragraph 26, you refer to an issue concerning your imprisonment for rent arrears in 2016, 2017. What you seek to do, I think, is cast this as being an issue that's related to the defendant's failure to pay you. But first of all, stepping back, do you accept that when these issues arose, this issue with imprisonment, it's over 2 years after the expiry of the fixed term of your third contract?
Yes.
And then can I ask you to look, please, at page 945. This is just to address what appeared to be an implication that this was somehow something to do with your landlord rent from some residents in Dubai. But if we look at this, it's from the Fujairah Federal Court of First Instance Execution Department, 5th of April 2017.
Yes.
And it says that certifies the Fujairah City Centre has been awarded the executive lawsuit against Fabiola Trading Company, represented by Mr. Musab, and a total amount of 418,000 dirhams. The file has finally been closed for full payment. So it's right, isn't it, that what this is actually about was the failure of a company you owned in Fujairah of Fabiola?
I was a partner. I was not the owner. I was a partner.
Yes, but it's about a company. It's Fabiola's failure to pay this, and you're, for one reason or other, caught up in this claim for payment. So
Yeah.
I understand this is a restaurant business, something to that effect. Yes.
Sorry.
This was a restaurant business, something like that.
Yes. It was a shop. Yeah, a restaurant shop. Yes.
So this is nothing at all, does it, to do with the defendant or Sudatel or your engagements with them?
No, not at all.
And it's about a rental of business premises, not residential premises in the UAE.
It's a shop. Yes.
Yes. And if we go then to page 924. And you can scroll down to 925 as well. It's quite a short point here, but
yeah,
it's right, isn't it, that despite the fact that it wasn't obliged to do so, EXPRESSO paid this amount to cover your bill.
250,000. Yes. But the main point, I requested the company, since if you see since 2014, the amount proposed by the defendant was 429,000 dirhams. And my claim was higher than that. However, the boss.
I think Mr. MUSAAB stopped for me. I don't know if he stopped for everyone else.
Yes, he's frozen.
Yeah, I missed it as well.
Hello?
Could you please repeat that, Mr. MUSAAB?
Yeah, do you hear me now?
Yes, you just froze for a couple of minutes. So if you could go back to the beginning of that answer, please.
Yeah, it's true that the total amount, as you mentioned, as you showed earlier, for Fujairah court was 418,000, and the total amount the defendant admitted to pay in 2014 was since 2014 until I filed the case in 2019 was 429, and later it became 397. So my point was, if you pay me at least the amount that you admitted, which is 429, I would have been able to pay 100% the amount required by the Fujairah court, which is less than the 429. And even when the defendant paid 250, I requested them to pay the full amount that they agreed at least, so I can lift the travel ban, because this amount was a bail, but the travel ban remained until the rest of the amount was paid. And I said, I need you to pay the entitlement, which had been now late at that time by more than 2 years, so I can lift the travel ban and go back to my work in Sudan. And this resulted actually not paying the money, resulted to Sudatel taking an action later on, and I lost my job because of that. So that was an issue which I highlighted, and there were a lot of liquidated damages there, being detained and losing the job, and even paying the extra cost because of the legal fees, etc., and so on. All of that would have been avoided if the defendant paid the.
I've lost the sound again, I'm afraid.
Yes, same here. We lost you again, Mr. MUSAAB. We lost you in the. Can you carry on after you spoke about the loss of your job? What were you saying after that?
Yeah, I've said if the defendant paid the amount at least which admitted to the 400 plus since 2014 or 2015 or even 2016, I would have avoided being detained or losing my job or paying extra costs related to that case. So.
Okay, Mr. MUSAAB, there's a last broader topic that I want to go over with you, probably in a little bit of detail, but it relates to the work you carried out, how it was carried out. we can see in your contract, for second and third contract, that you were initially engaged as a network planning and operations director, and subsequently to either chief technical or chief technology officer. I think the wording changes.
Yes.
This with broader questions, your role, I think, is very much focused on Sudatel's networks and its operations, as opposed to being, for example, a head office type job that you might expect, say, in finance. Is that a fair summary?
No, I have always been mainly responsible for EXPRESSO operations and business in West Africa, submarine cable, and everything else related to EXPRESSO. For some time,
I should perhaps rephrase, because I think I might have been misunderstood. When I say head office, I'm not trying to say between EXPRESSO and Sudatel. I'm just saying your role seems to be very much one where you're out at the front of operational activity, as opposed to sitting down like the chief financial officer and pouring through audits and accounts.
Yeah, my job required me to be on site, visiting the operations, meeting with the suppliers, and so on. It's different from finance CFO, for example. Yes.
Yeah, so it's based on my understanding, it's you're dealing with your technology suppliers. So is that firms like Huawei, ZTE, and so on, and
Yes.
you're delivering, installing, commissioning network components in Sudatel's
In
sphere of operation.
EXPRESSO, not Sudatel. It's in EXPRESSO's operations in West Africa. Yes. And for a short time, I helped Sudatel as well with my expertise and knowledge, according with the instructions of the defendant. Yes.
Yeah, and I think that you accept that none of those physical operations were in Dubai. I think you said that in paragraph 23
Yes.
of your first statement.
Yes.
So it's
Dubai office was a holding office. Yeah, holding company office.
Yeah. So you're on project delivery. You're with either EXPRESSO, Sudatel subsidiary companies in Senegal and Ghana and Mauritania, that sort of thing.
No, I was not a project manager. I think you misunderstood the point. I was the head of the technology in the whole group. I was the one deciding which company we supply equipment from, what kind of technology we need to get, how many sites or equipments, how much investment. I used to negotiate the contracts. That's my job. I was a senior executive of technology in the company. We had project managers and operation directors in each country, which used to report to me about the operation KPIs, etc., and also about the projects in each country. So I wasn't responsible to go on site, look after the projects. I set the plan and have project managers to look after that.
Yeah, and it's paragraph 23 of your witness statement. You say that in September 2009, you relocated to Sudan, and at that time, you're responsible for planning and operation of Sudatel's networks.
No, Sudatel had its own team, its own planning department. I was helping them because I had the expertise of the GSM 2G, 3G networks, which I acquired while I was in Sudan, because at that time, Sudatel did not have its own 2G and 3G network. So I helped them. And at the same time, I was doing the same transformation of the technology of the defendant in Senegal and Mauritania. I changed again the technology there. I designed and deployed new networks in Senegal and Mauritania as well to change to the 2G and 3G technologies, which we Sudatel as well requested to have.
Yeah. Yeah, and
so
that's
I was not responsible for the planning division department inside Sudatel. The planning team were totally independent. I was supporting them. And this is why my contract was saying planning division manager of EXPRESSO HQ.
Yeah. So if we look in that context, for example, page 981 of the bundle, we perhaps get a bit of a snapshot of that.
981?
Yes.
Yeah.
So we see there, I suppose, a couple of things. First, at the top half of the page, we can see the extent to which you're constantly entering, exiting the UAE, yes?
Not only UAE, all the countries.
Elsewhere, yes. But there are other passport pages.
My passport used to expire before I used to renew passport before they expire because of
one of those thicker ones. And the second thing we see here, just for convenience while we're here, the bottom half of the page, we can see your residence visa,
Yes.
but that only starts on the 25th of March 2016. So the first
Yes,
time you
sir.
get a residence visa is the end of March 2013.
Yes.
So prior to that time, so from the stint from 2008 up to 2013, you don't have residency. Presumably, you would accept that it must be the case that then you were never in Dubai for a period longer than 30 days, which would have been your tourist visa.
Not in neither in Dubai, neither in nor in other countries. I've been always, as I said, since my employment, I was traveling intensively because of the nature of the business itself.
Yeah.
However, my base was in Dubai, inside Dubai office of the defendant. I have my own office, all my documents, everything is there. My address,
Yes.
my phone, mobile number, everything is Dubai number. I didn't have mobile number for in any other country.
Yeah.
And that
And in fact,
mobile number was paid by the defendant. My mobile number was an international number with roaming service paid for by the defendant for 6 years.
Yeah. If we go to, for example, page 793, which is your first contract. $893. Yes.
793.
793, Michael.
700, oh, sorry, 700, sorry, 793. Yeah, yes.
And one of the provisions that you have relied on in your claim is this clause 1.2. It says the place of work shall be the company's Dubai office. However, the company reserves the right to require the employee to work at or be relocated for business reasons to any such other company work locations deemed necessary. The company shall support the displacement in a reasonable manner. The employee agrees that he may be required from time to time to perform services for associate companies forming part of the EXPRESSO group of companies. So this seems to be broadly consistent with what you've described. The idea is that you're going to be working in various different locations, often not in the same place, but predominantly based where operations actually are in Africa.
No, actually the intention, to my understanding, the intention of that article is to give the right to the defendant to relocate the employee if needed. So it's not the standard, was not the default or the initial agreement. So the initial agreement, as has been highlighted, is the Dubai office in Article 1.2. The place of work shall be the company's office in Dubai. However, it's just the right that given to the defendant. It might use it and it might not.
Yeah. And just on that, the place of work shall be the company's Dubai office. If you look at the very top of this page, do you see this agreement is between?
Yes.
And then bullet point 1 it says EXPRESSO Telecom Group Limited. And then it says whose registered office is at 3103 Saboteur 1 JLT Dubai, United Arab Emirates. Yes?
Yes, absolutely.
So when we're talking about the company's Dubai office, presumably you would accept that what's meant by this is their office in JLT.
Yeah, and that's been stated clearly in all the 3 agreements.
Yeah, I was just going to take you to that. So if you go to page 877.
Yeah.
Which is the second agreement. Sorry, Mr. Musab, have you? Oh, you are still there. I was worried you were frozen. But do you see at the top of page 877?
Yeah, the
same
same.
thing. Sabotage JLT, and then the next one is 889.
Yes.
The agreements between EXPRESSO, and it says the same thing again on the third agreement, 3103 Sabotage JLT Dubai. Yes.
Yes.
And then just complete that picture. If you go to page 983.
Yes.
I think this comes on to something you were referring to earlier about your phone number and everything else. So on the right-hand side, I think we've got your business card, which has the job description from your first contract, the Network Planning and Operations Director.
Yes.
And there it says that your office address says that it's in JLT, yes?
Yes.
And then if you look on the left-hand side of that page, I think we've got your third contract job title,
Exactly.
Chief Technology Officer.
Exactly.
And again, the address that's provided there for the Dubai
Yes,
office is JLT.
Yes.
So on the occasions when you have to come to Dubai in between what you call assignments elsewhere, it'll be working at or meetings in the JLT office.
Yes, exactly.
Okay. Now, I understand that at the time you enter into your third contract in 2012, you're the Chief Technology Officer. We can see that from your business card. My understanding in terms of structure is that effectively you're the most senior technical position within the company.
Yes.
So is
I used to
that
report to the CEO. Yeah.
thank you. Is that a direct report into the CEO?
Yes.
And I think that as part of that, you were appointed, as I understand it, a member of Sudatel's group executive management team.
Yeah. Yeah, exactly. When I joined Sudatel, I was also on the top management level, and I was reporting also to the CEO.
Yeah, so you're on the group executive team.
Yes.
And my understanding is the group executive team, they're the most senior employees, they're based in Khartoum.
For Sudatel, yes. For Expresso, they were based in Dubai. All of them, including
Yeah,
myself.
but I think we're talking about group level, so we were talking about the Khartoum level. So you would have gone to, for example, group executive meetings in Khartoum.
Do you mean after 2014 or before that?
This is the third contract, so 2012, I think, to 2014.
Yes.
You talked about your Skyward statement earlier, which shows us at least some of the travel that you were doing, at least when, as you say, you were with Emirates. And I think presumably, given that we're talking about Emirates Airline, what actually this document will show us is when you're traveling to or from Dubai or when you're transiting through Dubai. Do you agree with that?
Sorry, I didn't get the question. Can you say it? Can you rephrase it?
Yes, just given that we're dealing with a Skyward statement, one would assume that that's going to show us flights where either you're going to Dubai or you're flying from Dubai or you're flying somewhere via Dubai.
Yeah, Dubai was the base of my travel.
Okay, I just want to explore a little of that with you during, this will be during your third contract. So if we could start just to try and, I suppose, build a bit of a picture of your movements, just so we can try and understand this. If we go to page 811, have you got that page?
Yes.
Apologies in advance. This may be slightly laborious, but it's just important to get a bit of an understanding.
It's all right.
At the top of that page, there's the entry, which is the 25th of October 2013. But actually, if we look to the right, what we can see is that it's talking about a flight from Khartoum to Dubai on the 24th of October 2013. Can you see that?
Yes.
So what that suggests is, well, prior to the 24th of October, you're in Sudan. The grid light doesn't show it, but logically you must be, if you're flying from Khartoum to Dubai, that must be where you're coming from. Would you agree?
Yes, of course, yeah.
And just to, I'm going to come back to the Skyward statement briefly, but just to show how this is reflected, if you go to page 995, very briefly.
Yes.
And this is what you were talking about earlier. We've got a lot of passport stamps from a lot of countries, but on the bottom page here in the middle, do you see we've got the 25th of October 2013 UAE entry stamp?
Yes.
Yeah, so that's the passport entry from this trip. You've come from Khartoum, you've been stamped in Dubai,
Yes.
and that we can see on your Skyward statement.
That's true, yeah.
Yeah, so if we go back then to page 811, so we have that in front of us. Now, you may not have a calendar in front of you. It may well be that you're able to double check this if you want to using the calendar function on your computer. But just so we know where we are and what we're talking about at this time, the 24th of October 2013 is a Thursday. The 25th is a Friday. So what that would suggest with this flight is that you're leaving Khartoum on Thursday, probably Thursday evening, and you're arriving in Dubai on Friday.
Yes.
Does that sound about right?
Yeah, it seems so. Yeah.
Yeah. And if we go to the bottom of page, well, I think it's the bottom of page 810 and the top of page 811, because this goes in reverse chronological order. So just as we move forward, we're actually going to be moving up the page. You'll see an entry for a flight from Dubai to Khartoum on the 27th of October 2013. That's at the top of page 811. Do you see that?
Which page, please? 811?
Yeah, right. It's the very top. But
Yeah.
the entry
27,
begins on the page before. So you see 27th of October 13, DXB KRT.
Yes.
So that suggests, would you agree, that in this occasion you're in Dubai for 2 days on the 25th and the 26th,
Yes.
and then you fly back to Khartoum?
Very clear. Yes.
And again, you won't have it directly in front of you, but we've just looked at the days. The 25th and the 26th of October 2013 are Friday and a Saturday. So
Yeah.
I know it's changed now, but would you agree that at that time, back in 2013, Friday and Saturdays in Dubai are weekends?
Yes.
So we're now on page 810. And on the entry just above, it's the timestamp is the 3rd of November 2013. And we see there are 2 flights in that entry on the 31st of October and on the 3rd of November. So this is in the middle of the page. So this shows us that you fly Khartoum to Dubai on the 31st of October, yes?
Yes.
So what that means is that up until that point, you've been in Khartoum for the working week. So that's Sunday the 27th through to Thursday the 31st. Do you agree?
Yes.
And then we see with this flight, you spend another 2 days on the 1st and 2nd of November. So that's the weekend days, Friday and Saturday before Sunday the 3rd, which is the first day of the following week. It appears that you fly to DKR, which I think is Dakar.
Yes, that's true. It's Dakar, yes, Senegal.
Yeah. And then this is still on 810. It's the next entry above. We have a flight. This one is on the 6th of November, Dakar to Dubai. Do you see that? Do you see that entry?
In page 810. Yes.
Yes. So 6th of November, DKR, DXB. So what that shows us, I think, is that you spend 3 days in Dakar, and then you fly from Dakar to Dubai. This is on a Wednesday, the 6th of November.
Yes.
And then if we scroll up to the top of this page, at 810 still, we see that the next flight out is the 10th of November, 2013. That time it's Dubai to Khartoum.
Yes.
So that suggests that you've come back to Dubai on Thursday. You've been there for 3 days. So you spend Friday and Saturday. So that's those weekend days. And you're then flying back from Dubai to Khartoum on Sunday, the 10th of November, 2013.
Yes.
Okay, previous page, 809. And this is towards the bottom of the page.
Okay.
We see that the next flight is the 14th of November, 2013. Khartoum to Dubai. So again, tracking through those dates, you're in Khartoum for 5 days until the Thursday, 14th of November. And then again, at the end of the working week, you're flying back from Khartoum to Dubai.
Yes.
And if you then go to the next entry above that in this page, we see the flight on the 17th of November, Dubai to Khartoum. Do you have that?
Yeah, I do.
So again, this is spending 2 days in Dubai, Friday the 15th and Saturday the 16th. And then you're flying back to Khartoum on Sunday, 17th. Yes.
Yes.
So just taking that initial snapshot of what we've looked at, would you agree with me that what this is a pattern showing is you spend a working week in Khartoum, you then spend the weekend in Dubai, you spend another working week in Khartoum, then the weekend in Dubai, you then go to Dakar for a working week, back to Dubai, where you spend the weekend, before you then spend another week in Khartoum, again coming back to Dubai in the weekend. Yes?
Yeah.
So the time that you're spending in Dubai in this window aren't working days for the most part. You're there for the weekend.
Yeah. In these two instances, yes.
Okay. Moving forward, this is still 809. You've looked at the 17th of November Dubai to Khartoum. We then see that the next entry is the 30th of November 2013, Khartoum to Dubai. Do you see that?
809, yes. I can see
Yes. So on this occasion, what seems to happen is you have gone to spend the next 2 full weeks in Khartoum, coming back to Dubai on the 30th of November, yes?
Yes.
And then if you go right to the top of that page, 809,
Yes.
you'll see the 14th of December flight, Dubai to Khartoum. Yeah.
Yeah, I can see that, yes.
So in this occasion, it looks like you've been in Dubai for 2 weeks before you fly back to Khartoum on the 14th of December. Yes?
Exactly. Exactly.
Okay. And then if you go to page 808, do you see the next flight there at the bottom of the page, 30th of January 14, Khartoum to
Yes.
Dubai?
Yes.
Yeah. So from the 14th of December through to the end of January, that's about 7 weeks, you're in Khartoum for the whole time.
Yeah, for 2 weeks, yeah?
Seven,
That's
7
it,
weeks.
6
Yeah.
weeks.
It's actually 7 weeks because of the length of the month, but
Okay, yeah, it's all right.
as we can agree from the 14th of December
It's okay,
through
it's
to
okay.
the end of January. And that's then when you next come back to Dubai is the 30th of January, yes?
Yeah, the 3rd of January.
30th of January.
3rd of
And then the
January.
entry above shows us that on that occasion you're there for Friday the 30th. You're there for Saturday and Sunday, the 1st and 2nd of February. So it's another 3-day stint over the weekend. Then we see the next flight is back to Khartoum on the 3rd of February in the middle of the page. Do you see that?
Yes.
And on this occasion, if we look at page 807, you're in Khartoum from the 3rd of February. You spend the next 3 weeks there. And then at the bottom of page 807, what we can see is that you take a flight from Khartoum to Lisbon, bottom of the page on the...
Yes. Yes, 22nd of February, from Dubai to Lisbon, yeah.
Yeah, we can see the dates. The dates are at the top of page 808. So you start your flight.
Okay.
Apologies, I've referred you to these are slightly out of order. In the middle of the page, you'll see the Khartoum to Lisbon flight. It's the first full entry starting the 15th of March 2014 on this page. But the flight out is the 20th of February, Khartoum to Dubai. So you're transiting, and then Dubai to Lisbon on the 22nd.
Yes.
Can you see that?
Yeah, I can do. Yeah, I can see that. Yeah.
So you've had 3 weeks in Khartoum. You then fly to Lisbon. You're there. If we scroll down, and this is at the top of page 808. Your return trip, you go on the 28th of February. You start your flight in Lisbon. and then you're transiting through Dubai to Khartoum, where you arrive on the 1st of March 2014. Do you see that?
Yes.
And then the next time that we have a date of you leaving Khartoum, once you're back from Lisbon, is the 6th of March, which I think is at page 808. Sorry, yeah, page 808, right at the top of the page, 6th of March, Khartoum to Dubai. Do you see that?
Yeah.
So it looks like you fly to Dubai on the 6th. If you
Yes.
go up to page 807, right at the top, the next flight we have is Dubai to Khartoum on the 15th of March. So what that shows us is you've flown to Dubai on the 6th, you have a working week and the weekend in Dubai, then you're back to Khartoum on the 15th, yes?
Yes.
Yeah. So we're now at 808.
Sorry.
Page 808.
Yes.
This is the full entry towards the bottom of the page. We see another flight, Khartoum to Dubai. So that suggests that you've gone back on the 15th. You've spent the working week in Khartoum until Thursday, the 20th of March. And then you fly back then to Dubai. You have that? Khartoum to Dubai, 20th
Yes.
March.
Yes. I do.
Don't worry, I'm getting towards the end of this. What we then see is you spend the following weekend and the working week in Dubai, and then you fly back to Khartoum on the 30th of March. 30th of March, yeah, 10 days. So it's a working week and the weekend. 30th of March, middle of the page, you fly back to Khartoum.
Yes.
And then if you look at the next slide above, what we see is you then spend the whole of April in Khartoum, and you don't come back until the 1st of May, 2014. Yes?
That's what it shows. Yes.
When you do come back to Dubai on the 1st of May, you do a similar trip again. You stay for the working week plus the weekend. And at the top of that page, 806, we can see you fly back to Khartoum on the 10th of May. Do you have that?
Yes, I got that. Yes.
And then
Another 9 days in Dubai.
yeah, and then from the 10th of May, we can see that the only other trip that you take is a return trip from Khartoum to FTO, which is Rome.
Yes.
So that's from the 21st of June through to the 27th of June. But the rest of the time there, you're in Khartoum. Yes?
Yes. This according to the statement, as I highlighted, some flights were on other airlines like Ethiopian Airlines, Egypt Air, Qatar Airways. Those are also the Turkish Airlines. Sometimes we used to have tickets on those airlines. However, based on the Emirates Skywards, what has been highlighted is very true.
Yeah.
And
So
even what you
just
highlighted, I think you're trying to say like going to Khartoum for the week and being in Dubai during the weekend. So it makes sense that business assignments or business trips or meetings will be during the week, during the weekdays, not the weekend. And at that time, my family, according to the contracts that I provided with my wife, and I got my first child in 2013, my second child in 2014. So they were in Dubai. Okay. So it makes sense that I was based in Dubai I used to go to Khartoum. I used to go to Europe, to Rome. I used to go to Senegal, West Africa. That's part of the business, and that how it has been the whole time since 2008. I've been flying in and out.
So just to kind of round that off, would you agree with me that the majority of your working weeks, from what we've looked at there, have been spent in Sudan?
Not all of it, only end of 2013 and part of 2014, because at that time I was helping the defendant. I was helping Sudatel to establish, or let's say, restructure. That's the correct word, to restructure its planning division, and I helped them, and we did the full restructuring of the planning division during that period. So at that time, there was a new CEO for Sudatel, and he requested me, and he was the chairman of EXPRESSO at the same time, to help in Sudan for that period. So I was going there, but as you have seen, I go there during the working days, and the rest of it, I'm in Dubai for other working days or for my normal weekends with my family.
Do you
so
agree?
That's very normal. Yeah.
Based on what we've just looked at, even on those instances where you are in Dubai, either it's because you're transiting or because you're there for the weekend, not during working days.
No, you see many times 10 days, 9 days, because most of the time I don't spend more than a couple of weeks in any country. Okay, so even you showed only one time when I spent like a month or so in Sudan, and I'm sure if we look at other airlines, we might find other flights on that during that period. As I highlighted, the Emirates Airlines used to go only to Dakar, so we used sometimes use Ethiopian Airlines to go to Guinea, to Ghana, Nigeria. Ghana sometimes used to go also, the direct flights and so on. So it depends on the destination, the airlines, and the availability of tickets. So I provided this in my reply to show that I was in frequent travel all the way through from 2008 to 2014, as shown there.
Would you agree with me? Sorry, is Mr. MUSAAB still there?
Yeah.
In that period we've looked at, out of about 40 working weeks, what that shows us is that you've only spent about 5 of them in Dubai. Do you agree?
I didn't calculate that, but as I highlighted, not all the period showed in the tickets in the Skywards flights reflect that I was in a certain city, because many times I used to take other airlines, and I highlighted that from the beginning. So if you, for example, if you see that I've been in a city for a month, it doesn't mean that I was there for the full month. I might have taken another flight on Ethiopian Airlines, Turkish Airlines, whatever, So that's what has been shown in the Emirates Airline. It shows that what the travel looked like, but it doesn't show and reflect the travel on other airlines. And as I highlighted, not all the destinations of the business of the defendant were used to have direct flights by Emirates Airlines.
Your Honor, I just want to check with my instructing solicitors whether there's anything else. If you just bear with me for a couple of moments, if that's all right.
Yeah, it's all right. Yeah, take your time. It's all right.
Okay, Your Honor, thank you.
Any re-examination?
Very short re-examination, Your Honour. Mr. MUSAAB, you were taken to, you were being asked about air tickets, and you referred to the document involving Mr. Nazar Sahal, and that you referred to that as having relevance to reimbursement compensation for air tickets. don't think you had the opportunity of looking at that document. I can take you to it. It's at page 854.
Yes.
Take your time to refresh that. Is there anything on that page which relates to air tickets that you would like to draw the court's attention to?
Yes, at clause 2, it says the company will pay you in lieu of cash any unpaid leaves up to September 30, 2009, and air tickets, if any.
Thank you. I think I can now take you on to, yes, you were asked about clause 18.3 at page 897.
Yes.
It may seem obvious in view of what we have at 983. Would you just look on to 983?
Yes.
The photocopies on 983 have already been confirmed as being your business cards in relation to Agreement 1 and also Agreement 3.
Yes.
Certainly 1 and it looks as if the other contains a business address or an address in Dubai, which is your name, under your name, yes?
Yes. So this is the company's address in 701 JLT.
So if we go back to clause 18.3 on page 897,
Yes.
all notices required to be given or information supplied by either of the parties to this agreement to the other must be in writing and shall be sent by hand. Was there a possibility of any notice or information being supplied to you by hand in Dubai?
Yes, it was possible.
And
Absolutely.
where could that have taken place?
In the office, in JLT.
And if it needed to be followed up by a registered post, could that have been done in Dubai?
Absolutely.
And where would that where is there an address that you can point to at which a registered post could have been sent?
Yes, yes, it's 701 JLT.
You were asked about and confirmed that page 981 is a copy of your residence visa.
Yes, yes, it is.
I think you may have given the evidence already. Are you personally able to obtain a residence visa, or does someone have to obtain it on your behalf?
It has to be requested by the company.
And in order to obtain a residence visa, what fundamental information needs to be provided to the authorities?
First, the employment letter, salary certificate, and I believe rent or residency proof. That's an address and so on. That's it mainly. Yeah. And then the health check afterwards.
And residency proof and address would be consistent with what we see at the foot of this document. A little bit unclear, but I think it says residence permit becomes invalid if bearer resides out of the UAE for more than 6 months.
Absolutely. Which didn't happen.
And I think all I need to ask you, Mr. MUSAAB, yes, indeed, that's all I have to ask you. Thank you so much. Does the court have questions for Mr. MUSAAB?
one, it may be something that council can help with as much as Mr. MUSAAB, but looking at the Sudatel contract of the 1st of September at page 845, and then looking at 852, where various figures are set out, we're talking about many years ago now, but can someone tell me the approximate value in US dollar terms of what looks like Sudanese currency? I assume that's Sudanese pounds, is it?
Your Honour, yes, it is. I can certainly help in this regard. And it's a point that had occurred to me. A letter has been, or an email probably has been sent by those instructing me to those instructing my learned friend, because it did seem to me that the court would be assisted by historic currency conversion rates. There are three currencies. There's AED, there is US dollars, and there are there are Sudanese pounds, which is the abbreviation SDG. I have located on the web an available source for identifying historic rates, and that I think has been put to my learned friends instructing solicitors for agreement as to the source of getting at the information that the court wants. In short, it is in hand.
All right, thank you. That's helpful. I mean, I've been able to look it up in today's terms, but I haven't looked at what it was back in 2009.
Particularly in the present circumstances, today's terms may be very different. Yeah.
Well, that's exactly what I'd assumed.
Yeah. We'll provide you with the information.
Very good. I mean, the easiest thing is just to compare with dollars, because the AED figure is steady against the dollar, fixed against the dollar. So
absolutely,
easiest to do that comparison.
Yeah, we can certainly do
if I may add, I recall that the rate around, it used to be around 1.5 dirhams for each SDG. So the gross amount is going to be like maybe around 9,000 dirhams, but this needs to be checked, as Mr. Michael has mentioned. And the net will be even less than that, because this is the gross, and then there are deductions out of that. So the total, even I highlighted that, I think, in my reply to defense, that together, the amount received in Dubai, the 12,500, even if you include the amount in Sudan, together they were less than 20,000 dirhams compared to 40,592 salary.
Well, I want to see that, because this at page 852, it's a net figure, because you have monthly salary less deductions plus annual.
Yes, exactly.
Annual benefits. So
yes,
I want to see how all that works out, please.
Yeah, Your Honour, broadly, and I didn't want to give anything that could be considered as evidence, but broadly, my researches are in line with the evidence that you have just heard from Mr. MUSAAB, but we will provide full details to the court.
Yes, very good. All right, now we're nearly 2:10 in English term. We were going to stop at 3. Should we take a very short break now and then start on the next witness?
Yes.
Is that all right, Mr. Doherty? Very good.
Yes, Your Honour.
Thank you very much, Mr. MUSAAB. That's the end of your evidence. No more questions for you. So you're free to come or go as you wish. And we'll take a 10-minute break now and then begin on the defendant's witness in just a moment. Thank you very much.
Obliged, Your Honour.
Yes, are we all set to continue? Mr. Patrick Joyce, are you there in
I am here, yes.
Thank you. All right. Can the witness then be sworn, please?
Certainly, Your Honour.
Thank you very much.
Mr. Ala, would you please state your full name and occupation for the record, please?
My name is Ala Hassan.
Yes. And what is your occupation?
I've
Mr. Ala, can you hear me?
Yes, currently I'm the head of quality assurance and compliance for Shingitel Telecom, which is a subsidiary of EXPRESSO Telecom Group, part of the bigger group EXPRESSO Telecom.
Okay, thank you. Will you be swearing or affirming today?
Swearing?
Yes. Do you have the Holy Book in front of you?
Yes.
Yes, please. Okay, please say after me. I swear by the Almighty God
Okay. I swear by the Almighty God
to tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Your Honor, the witness has been sworn in. Thank you.
Thank you very much.
Thank you.
Mr. Doherty.
Yes, thank you. Mr. Alib, if you could open up the bundle of documents to page 451.
51.
If you let me know when you have that.
Yes, 1 second. 451. Okay.
You should find a document titled Second Witness Statement of Ala Alib. Do you have that?
Yes, I do.
And if you can scroll down in that document to page 458. At the bottom of that page, we see your name, and it's dated the 1st of February 2023. Can you confirm that that's your signature?
Yes. Yes.
And have you had the opportunity to read that statement?
Excuse me?
Have you had the opportunity to read your statement?
Yes, absolutely.
Can you confirm that its contents are true to the best of your knowledge and belief?
Yes.
Thank you. And if you could look at page 469.
469.
You should find a document this time that says third witness statement. Ala Alib. Do you have that?
Yes. This is 469.
Yes. And if you scroll down to page 472.
472. Yes.
You should find your name and the date 15th of February 2023 and a signature. First of all, could you confirm that that's your signature?
Yes.
And have you had the opportunity to read this statement?
Yes.
Can you confirm that its contents are true to the best of your knowledge and belief?
Yes, I do.
Thank you. If you remain there will be some questions for you. Your Honour, as Mr. Pratchett-Joyce did, I shall, unless you wish me to do otherwise, switch off my camera to avoid any issues coming up.
Thank you very much. Yes, Mr. Pratchett-Joyce.
Thank you, Your Honour. Mr. Allah, do you prefer to be addressed as Mr. Allah or Mr. Aloob?
Mr. Aloob, that's a family name.
Mr. Aloob.
Yes.
Mr. Aloob, you've verified 2 witness statements. Would you
Yes.
look at page 488 in the bundle?
488.
Do you have it?
Okay.
And do you see
This
that document?
MUSAAB, yes, sir.
you see that document should be
Witness
identified?
statement. My witness statement.
Yes, and this is an earlier witness statement made on
Yes.
the 30th of June 2019.
Exactly.
Are you relying on that witness statement or not in these proceedings?
Yes, I am. Yes.
You haven't been taken to it, nor has it been verified. We may come back to that. Let me turn first of all to EXPRESSO Telecom. Could we begin by looking at page 793, please, Mr. Aloob?
793.
You have that?
793.
Yes.
Yes, 1 second. Okay.
And that should be the first substantive page of the agreement dated the 1st of November 2008. Is that correct?
Yes.
We're on the same
Yes.
page.
Correct.
And this agreement is made between EXPRESSO Telecom Group Limited and registered in the Dubai International Financial Centre, the DIFC, and then
Yes.
it gives a registered office, but not in the DIFC in Jumeirah Lake Towers, JLT. Do you see that?
Yes.
It's a matter of public record, but are you in a position to confirm that EXPRESSO Telecom Group Limited is indeed registered in the DIFC with registered number 494?
Yes.
And are you in a position to confirm that the registered offices given on the DIFC registry is Unit 101-102, Level 1, Park Towers, Dubai International Finance Centre, Dubai, postcode 57593, United Arab Emirates?
Yes.
So whatever may be the case in relation to other registered offices, the DIFC entity is registered under the number and at the office that I've just read into the record. That's correct, isn't it?
Partially correct. If I may explain, during the early days of registering EXPRESSO in the DIFC, the current office is located at the Makbak Towers, weren't erected yet. And therefore, we had to look for temporary offices. And that's why we temporarily located to JLT. However, at the time, we didn't know that JLT is at itself is a different free zone, which is DMCC, Dubai Multi-Commodities Center. And later on, we had to obtain authorization from the registrar of companies in DIFC to operate from JLT.
The registry records for the DIFC indicate that EXPRESSO Telecom has been incorporated since 2007. It has been in the
Yes.
It has been registered as a DIFC company since that date. Is that correct,
Yes.
Mr. Aloob?
Correct.
Now, in terms of what EXPRESSO does, is it right to say that first of all, EXPRESSO is regulated by the DIFC? We've seen that. Is it also right to say that EXPRESSO is an African telecommunications and information services company and might be described as an African brand for the people of Africa?
According to the initial vision, yes. However, if I may also explain, the whole purpose of organizing the office here in DIFC was to avoid the sanctions and embargo laws imposed on Sudan. And Sudatel company, being partially owned by the Sudanese government at the time, could not actually operate its operations fully in West Africa or in any other place without having an office outside and frame to be able to manage those operations.
Well, that's very helpful, Mr. Aloub. Would it surprise you to learn that what I've just read to you is the way in which EXPRESSO describes itself on the company's LinkedIn page, which is live as of yesterday?
Maybe it is, but I'm not aware of that website currently.
I see. And if we look back at the company overview provided by the DIFC registry, the business activities of EXPRESSO Telecom are described as holding company, communication engineering services, and corporate headquarters. Are those accurate business activities?
Absolutely. And if I remember correctly, also supposed to be a pre-IPO. Since Sudatel itself was listed in Abu Dhabi Stock Exchange, the idea was once the operations in West Africa show growth, that we can also list EXPRESSO in the Abu Dhabi Exchange.
But it is essentially a holding company and a corporate headquarters.
It is, yes.
And the main areas of work, consistent with the strapline, an African brand for the people of Africa, the main areas of work of EXPRESSO are Sudan, Mauritania, and Senegal at the moment.
Actually, Sudan was the main office, since EXPRESSO is 100% owned by Sudatel. EXPRESSO was intended to look solely on the operations in West Africa. At the time, Senegal, Mauritania, greenfield operations, Ghana, Nigeria, and Guinea were existing operations that Sudatel acquired at the time.
And that footprint, if I can put it in those terms, is consistent with the travel that Mr. MUSAAB has spoken about in giving evidence to this court earlier on today, isn't it?
I believe so.
Can we now look in a little bit more detail at the agreements in question? Looking back at the agreement on page 793, did you draft this agreement?
The template itself, no. The template was provided by the CFO at the time, based on a template used by other operation that was existing in the DIFC. I'm not going to claim that I drafted this. Plus, it was reviewed and approved by the legal counsel at the time.
Did you have any hand in drafting this document?
Specifically this one, no.
Who did?
I believe the management of the group at the time.
And if we go on to page 876.
876.
That should be the second agreement, which is dated the first.
This is,
Sorry,
yes, 876. This one I drafted.
you drafted this one.
Yes.
And for the sake of completeness, if we go on to 889.
889.
Yes, please.
Okay. Is 889.
Should be the first page of the agreement effective the 1st of August 2012.
Yes.
Again, did you draft this one?
Yes.
I think it's probably right to say that in drafting the agreements of 2010 and 2012, you were following the house style which had been set in the earlier agreement of 2008.
Yes.
And we've already seen one oddity in relation to a particular clause in the first agreement, which has been carried over to the other agreement. So you were simply carrying over the template, were you?
Yes. Yeah.
And these agreements are what they say they are. They're the employment of the claimant by EXPRESSO. That's what it says, isn't it?
Excuse me, can you repeat the question,
Yes,
please?
yes. These documents are what they say they are. You, as a director of human resources, knew what you were writing, and they are what they say they are.
Absolutely, yes.
Now, can we look at, whilst we're looking at all the agreements, let's look at page 845.
$845.
Again, did you draft this?
Just 1 second. 845. No, this is drafted in Sudan by Sudatel.
Yes. So it was provided to you by Sudatel, wasn't it?
I believe, yeah, at a later date and time.
And if we look back at page 452, please.
452.
Yes, please.
Okay.
Do you see paragraph 3 at the top of that page? Where the contents of this witness statement are within my knowledge, they are true. Where the facts and matters are not within my knowledge, the source of my information is stated, and the facts and matters concerned are true to the best of my information and belief. And there's a similar paragraph in your third witness statement, and indeed in the first witness statement, which hasn't been verified. Do you accept that,
Yes.
Mr. Aloob?
Yes.
I don't think anywhere you tell us who provided this document, when it was provided, who requested it. There's no information of that source at all, is there?
You're talking about the one drafted in Sudan?
Yes.
Okay. Basically, I believe this came at a time when we were trying to calculate, or I think there were discussions of settlement between the group management and Mr. MUSAAB. And during that time, in order to make sure that there were no salaries paid in Sudan, I contacted Sudatel HR, and they provided the contract, and they also provided the statement of account showing the salaries paid to MUSAAB.
Yeah, I had no doubt that you took those steps, Mr. Alou, but the point is somewhat different. If we look back at, could we look at page 488 to begin with?
488?
Yes, please. And on 488, that's the first page of your first witness statement. Yes, if we look onto the next page, 489.
488, just 1 second. 488. Okay, this is 488.
Yes.
Yeah.
And then we can see from the, if we go on to 489, we can see from the foot of the page that the exhibits to this witness statement all begin AA1. Yes?
Yes.
And then if we go over the page, we can see that footnote 2 identifies the Sudatel employment contract between Sudatel and the claimant as being annexed as exhibit AA12. Yes?
Okay, I believe so.
And that is the document we are looking at page 845, isn't it?
This is 490 actually.
490 is the reference to
Yes.
exhibit AA1-2, the
So go back
Sudatel
to
employment
48
contract.
So go back to 485.
845 is the document that you exhibit, isn't it?
I'm sorry, can you please repeat the number of the document?
Yes, 845.
845. Okay.
845.
845. Just 1 second. Okay. This is 845. The Majmuat Sudatel, or this contract is made the day of the 1st of September.
Yes, and that is the document
Yeah.
that you are exhibiting as footnoted at footnote 2 back on page
Yes.
490. Yes?
Yes. Yeah.
So let's go, I just want to make sure that we got the right document. Let's go back to page 490, if we may, Mr. Alou.
490. Okay. 490. This is 490.
Yes. Now let's read from towards the right-hand side of the second line. I am also given to understand from the team at Sudatel that the claimant has been drawing a monthly salary from Sudatel. I was given a copy of the statement of account of all the remittances made to the claimant's account in Sudan. Clearly shows that the claimant was receiving a monthly salary from Sudatel. This is
Yes.
all information from someone else, isn't it?
Yes.
Back at paragraph 2, the previous page, 482.
482.
The end of paragraph 2, where reference is made to facts which are outside my knowledge, which we've just established all this is, I set out the source of my information. Well, where do we find the source of your information, Mr. Alou?
Again, can you please explain the question?
Yes.
I can't see the point of the question.
Oh.
I'm given to understand from the team at Sudatel the claimant's been drawing a monthly salary. He's told
Yes,
you where he's got the information from.
Well, but not the person. He's not the person who.
Well, does it matter? He's told you it's not within his own knowledge, and that's where he's got it from.
Well, Your Honour, I can't take that aspect any further, and I'll move on.
I'm deeply sorry, but if I may add, it came to my surprise actually Sudatel during that same time. And I knew that this is eventually will cause problems because of the different jurisdictions, which is unfortunately, if I may say, our group at the time didn't know or they weren't aware about how to begin certain contractual agreement with an executive in one area and to end it before they go and begin another one. However, that was then.
But what you've just described applies to this case, doesn't it? Because that was then, as you rightly say, Mr. Aloob.
Yes, yeah.
Yes. Now, let's look at page 845 while we're looking at it. Or at least if 845.
845.
We see that on page 845, there's an area identified, don't we? Do you see that?
I'm sorry, but your voice is breaking.
Oh,
can you just repeat the sentence?
Yes, 845.
Yes.
If we look down on the English text, it says area EXPRESSO HQ.
Is it 845? The second party agrees to be appointed the first party position planning KIDA area EXPRESSO HQ. Yes.
Thank you. And this is a Sudatel document, you've told us, and Sudatel knew that it was the holding company of EXPRESSO, didn't it?
Yeah, but Anna, I think I have the explanation for this. So this is based on what became known to us at the time, that MUSAAB or Mr. MUSAAB, he was bound by the non-compete clause included in his previous employer, Zain Sudan. And that's why when he first accepted Sudatel or EXPRESSO offer, it became obvious that he cannot join EXPRESSO or Sudatel. However, they managed to keep him there for like 6 months, and then they began, I believe, paying him salaries. I'm just trying to fill the gaps, but
well, Mr. Aloob, if you don't know, trying to fill the gap won't help, and that is not what you say in paragraph 4 of your first witness statement on page 489.
Because if you look at the dates,
well, wait a minute.
For example, if you look, when you see that he was bound by 6 months non-compete clause, and you see the initial start of EXPRESSO contract and the time when Sudatel started, or when he first became known to us that he joined Sudatel, it actually fits what's happening. And by the way, I'm not trying to MUSAAB was a friend and a colleague and an executive, and I believe he's not in part responsible for the mess, and I think the group altogether was responsible for this.
Well, I'm much obliged for your acknowledgement in that regard, but can we go back to paragraph 4 on page 489, please.
Yes. 489.
Do you have paragraph 4?
Just 1 second. 489. Okay. This is 489.
And picking it up along the first line, I, that's you, Mr. Aloob, state that the claimant was first offered employment in the defendant company in November 2008. She expired on the 31st of October 2010. We'll come back to the dates in due course. I'm given to understand that the non-compete clause operating against the claimant pursuant to a prior employment prevented the claimant from joining earlier than November 2008.
Yes.
So I'm given to understand the employment terms that the claimant had with Zain contained a non-compete clause according to which any employee that leaves was prohibited from working for any competing organisation for a period of 6 months. So
Yes.
the non-compete with Zain prevented Mr. MUSAAB joining EXPRESSO until November 2008.
Yes.
That's the position, isn't it?
Just considering the duration of time, I'm very sorry to say that it will be very difficult for me to follow on the dates unless I can, how can I say, have it written in front of me, because I cannot recall all of this. This is a long period of time to cover.
Mr. Aloob, you have your own evidence in front of you in writing, and that's what I'm putting to you.
Yes.
So if the non-compete prevented Mr. MUSAAB joining until November 2008, it cannot have anything to do with the situation in September 2009, can it?
Well, honestly speaking, I cannot elaborate about what was happening in Sudan. The fact that I know that once I received the Sudatel agreement, it became very clear that he signed an agreement there, and he received amounts of money there that we weren't aware of. That you see, the rule, the simple financial rule that I follow here is that if the finance department show me a provision for entitlements at the end of each year that an employee spent in the company, then it becomes binding. However, whenever he claimed, or when he claimed many entitlements that I didn't have any record for, or the finance department couldn't show any proof that this is contractually his, I could not just approve it, and that's why I went and I asked him. Yes.
We will come back to the finances in due course. We can't do that today. We'll have to do it tomorrow. But if we go back to page 845, please. This is the last point today.
845.
Do you have it?
Just 1 second. This is 845.
Do you have it, Mr. Aloob?
Just 1 second. 845. 1 second. This is 845. Okay.
And here we see that Sudatel is identifying the area covered by this document as EXPRESSO HQ, yes?
Okay.
EXPRESSO is registered in the DIFC. Sudatel is in Sudan. That's correct, isn't it, Mr. Aloob?
Yes.
So when Sudatel identifies the area as EXPRESSO HQ, they are being very precise, and they are talking about EXPRESSO.
Exactly,
Yes.
because he was hired as a director in EXPRESSO Telecom Group to look after the operations in West Africa.
Thank you. I do see that it's 3 o'clock. I know that there's a hard stop at 3 o'clock, and it happens to be a convenient point to break.
Yes, all right. Thank you very much. Mr. Aloob, because you're in the middle of giving your evidence, you mustn't talk to anybody else about the evidence you're giving or about this case overnight, you understand?
Okay, absolutely.
Thank you very much.
Even my counselor?
No,
Sorry, Your Honor, I was just going to jump in just to request that. I noticed that there were some instances where Mr. Aloob, it took a little bit of time to pull up some documents.
yeah.
I obviously don't want any of my solicitors to speak to him about his evidence. I wondered whether if it was convenient for both my learned friend and for you, Your Honor, we could perhaps try and pick up with Mr. Aloob to make sure we're aware if there's any issue with the technology that he can be brought through just to pull up page references quicker if possible.
Your Honour, I'm very happy with Malone and Friend's proposed course of conduct. I'm sure he will observe propriety. And if, for example, a PDF copy of all 56 pages can be made available in a page search format, so that all Mr. Aloob needs to do is key in the number that I give him and the page comes up, I think we will progress a lot faster than we've been able to do this afternoon.
Yes. All right. Well, I'm sure people have been listening to that. So let's try and make life easier for you, Mr. Aloob. All right. Thank you very much.
Thank you.
So same start time tomorrow, please. Thank you very much
Absolutely.
indeed.
I'm obliged, Your Honour. Thank you so much.